Christians. Miss Christians, you are with us, eh? Please call the case, Ms. Kabisa.
Good morning, Justices. I am the registrar for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter Social Justice Coalition and others, and the Minister of Police and others for hearing. Counsel are now invited to place themselves on record. Please know that this hearing is being recorded.
Thank you, Mr. Kamisa.
May it please the court, I appear for the applicants together with my colleagues, Ms. Mayosi and Mr. Bishop.
Thank you, Mr. Hawthorne.
May it please the court, justices, I appear for the respondents, the first, second, and third respondents, together with my learned friends, Ms. Pillay, Mr. Naidu, and Ms. Matsala.
Thanks, Ms. Williams.
May it please the court, justices, I appear for the fifth respondent, the Women's Legal Center Trust, together with my colleague, Ms. Fatima Jera.
Thanks, Ms. Christians. Yes, Mr. Hawthorne. I have informed colleagues that you said we may engage you right from the beginning, and let me do so. On first principles, an appeal is lodged against a judgment, or perhaps let me more specifically say an order. What exactly is the appeal against here?
Justice Madlanga, the appeal is against what the applicants contend is the constructive refusal by the Equality Court to grant them a remedy. That is the primary basis on which the applicants approach the court. In the alternative, the applicants request direct access for purposes.
Let's leave the direct access part aside for a moment. I just want to understand the outer contours of what you have just said and what indeed the applicants say in their papers. Let us say at first instance, there's been no hearing, there's been nothing at all. And the latest stage in the proceedings is a request for a date from the court, and the court never ever sets the matter down or never gives the parties a date. Can that be appealed against as well?
Justice Madlanga, the question of whether or not there has been a constructive refusal of, and I'm going to begin with the principles established by this court with regard to the new clicks matter, and then extrapolate from those principles and contend that they are applicable in the present case. In the new clicks,
bearing in mind though the example or scenario that I've posited to you, yeah.
Yes, in new clicks, the court held that an unreasonable delay in disposing of an application for leave to appeal will infringe the litigant's Section 34 rights, and an appeal court is in appropriate circumstances entitled to treat those that failure to determine the leave to appeal as a constructive refusal of that appeal, where there's been an unreasonable delay and the appeal court has been approached as a last resort. And so
refusal of appeal or refusal of leave to appeal.
Refusal of leave to appeal. So those are the principles that are established in new clicks, and in both is apparent from both this court's judgment in new clicks and the Supreme Court of Appeal judgment that a delay in determining an application for leave to appeal infringes a litigant's right of access to court. And our submission is that that principle, the infringement of the right, there's no reason for that to be limited only to applications for leave to appeal. That principle would be equally applicable to the failure to determine a matter if it's beyond the control of the litigant. And that's explicit in the SCA judgment in Nuclex at paragraph 31, where it says that there's the Section 34 right includes a right to a fair procedure, and a failure to determine a matter within a reasonable time and effectively infringes that right. So our submission would be that it depends on the circumstances of the matter, where in the example posited by yourself, there would be, one cannot rule out as a matter of principle.
Let us so that we just grapple with the principle. Let us say there has been a delay, very long delay that cannot be justified under any circumstances, so that we just zoom in on, can you apply those Glick's principle to a situation of a first instance hearing? Failure to give a date, allocate a date for at first instance. Do you apply the Glick's principles there?
Just as we would submit that there's no reason to, if there's an infringement of the right of access to court with regard to leave to appeal, then it would follow as a matter of logic that if there's an unreasonable delay in setting a matter down, which is what the case that we are concerned with now, that must also infringe the right of access to court. And our submission would be that it might be that the circumstances which would be required in order to establish a constructive refusal of a remedy, that one the circumstances would differ, and it might be that the court would say that the threshold to establish that constructive refusal of a remedy is higher than with regard to a leave to appeal, but the principle we submit cannot be different, that they will reach the point where it amounts to a constructive refusal of a remedy.
My last question on this aspect, if I do come in, it may be much later perhaps. Let us say this is a case which is a fact-laden, it's a trial, hotly contested factual issues. What then will be before the Court of Appeal? Will it only be the fact of the refusal, just that, and then all that the parties expect from the Court of Appeal is just a determination around this refusal or failure to allocate a date only, or will what was to be before the Court of First Instance also be before the Court of Appeal? What exactly will be before the Court of Appeal?
Justice Madlanga, I'm not sure if I'm understanding the question correctly, and if I'm not,
I'm saying what's before here. Thank you. What is? Oh, sorry. Let me hear you.
It would obviously be far more difficult.
No. I wanted to repeat my question because I thought you say you don't understand me, but then I saw that you were still speaking. So I was saying, let me hear you out before I clarify my question. I'm quite willing to clarify my question.
Justice, I'll answer what I understood the question to be.
No, let me rather repeat it there to make sure that you understand me. I'm saying at first instance, what would have been before the court for determination are the hotly contested factual issues and whatever law is applicable thereto. That is what is before the court of first instance. And then there is the interposition of the failure to allocate a date, and that is what moves you to come to the Court of Appeal. So what I'm asking is, will the two be before the Court of Appeal, there is the hotly contested factual issues. Does the Court of Appeal have to determine those as well, and whatever law is applicable to them, plus the question of the failure to allocate a date, the constructive refusal and so on? What exactly will be before the Court of Appeal? That's my last question.
Justice Malanga, I distinguish between the disputes of facts which you raise, which might impact on the remedy which is granted by the appeal court. It would obviously be extremely difficult for an appeal court consisting of whether the SEA of a panel of 5 or a panel of 11 in this court to determine those issues. So that would impact on the remedy that the court would grant in the event of a constructive refusal being justified or established. But our submission would be that it would not, in principle, affect the issue of whether or not there has been a constructive refusal. That the remedy would, in that instance, almost certainly have to be a referral back to the court of first instance, because the appeal court wouldn't be able to determine the issues that arise.
Mr. Hawthorne, thank you. In responding to the earlier questions, you seek to build on new clicks. One could argue that new clicks was quintessentially an excess matter because a leave to appeal regulates, as it were, one's entry to the higher court. And therefore, until leave to appeal is granted, that door is closed. And therefore, it fits and is aligned much closer to the question of excess. You have indicated that there's no reason why one cannot build on the principle outlined in new clicks, because as I understand your argument, the discussion around new clicks is located squarely within Section 34. And the right in Section 34 is a right to have a justiciable dispute decided, and that's the language that's used. In response, you indicated that one may need to set a higher threshold in matters that fall perhaps outside new clicks. And new clicks spoke of prejudice, it spoke of a measure of last resort. If one was to take up your invitation that indeed a higher threshold may be required, provided one gets through the other loops, what would the elements of that higher threshold be in your view?
Justice in that regard, it's our submission that the court would have regard to the principles established in the Wahlhaus matter. And in Wahlhaus, the test posited in those circumstances was based on an extract from Gardner and Lansdowne, which was adopted by the court in that case. And if I can just read the extract from Gardner and Lansdowne that was endorsed by the appellate division. It says, while a superior court might have to intervene in review or appeal in ongoing proceedings, and then the number of it comes in the following passage. In general, however, it will hesitate to intervene, especially having regard to the effect of such procedure upon the continuity of proceedings in the court below, and to the fact that redress by means of review or appeal will ordinarily be available. But the test that it is posited in Gardner and Lansdowne is that it will do so in rare cases where grave injustice might otherwise result, or where justice might not by other means be attained. And in our submission, that those are the circumstances in which one should consider extending the new clicks principles, where grave injustice might otherwise result, or where justice might not be attained by other means. So we would submit that those are the circumstances that should be taken into consideration and in determining whether to extend the new clicks principles.
And just lastly, from my side on this issue, I think one would recognize that the structure of the courts, and in particular their hierarchy, even though there's a hierarchy, is based on an underlying principle of the respect for the power and the authority vested in each level of the hierarchy of courts. If one was to extend the new cliques principle, isn't there real danger that those lines become blurred as litigants who, for whatever reason, might feel they can't wait any longer for a hearing date or for a judgment that's reserved in a complex matter, then approach the higher court, and that may well have the effect of undermining, as it were, the carefully structured architecture that lies at the heart of the hierarchy of courts.
Justice Collipin, those considerations were decisive in the SABC matter, where this court stated explicitly it was loath to prescribe to the SCA as to how it should regulate its procedures with regard to the televising of court proceedings. But it certainly, it allowed the judgment of this court in that matter, allowed for the fact that there would be circumstances in which this court would prescribe to the SCA. It didn't rule out that as a possibility in appropriate circumstances. And our submission would be that where the Wahlhaus test is satisfied, then it would be open to this court to do that. Obviously, the court would have a concern that it would open the floodgates every time there's a hiccup in proceedings in the high courts or quality courts, that parties would feel free to approach the court, and it would have to be made very clear that only in exceptional circumstances would such applications be entertained, and if necessary, the cost orders could be invoked to discourage litigants from approaching the court in circumstances where it is not appropriate to do so.
Would this not amount to piecemeal litigation, though, where one court will decide the merits and then a person approaches the appeal court for remedy, if we were to extend the principle as you propose?
Justice Mhlantla, it's the situation which has arisen on the facts of this case would result in the Equality Court have deciding the merits of the matter. And what is in dispute between the parties is whether or not the failure of the Equality Court to set the matter down for hearing amounts to a constructive refusal of a remedy. And if it is a constructive refusal of a remedy as contended for by the applicants, then that issue has been decided by the Equality Court, and the applicants are entitled, in view of that decision, to bring the matter on appeal to this court. And the reasons why the applicants have approached this court directly rather than go to the SCA has been explained by the applicants in their affidavit as a result of the limited jurisdiction of the SCA. And if we're wrong in our submission that there has been a constructive refusal, then the SCA would be obliged to strike the matter off the roll. And that's the reason why this court has been approached, because of the broader jurisdiction of this court to entertain direct access matters.
So, so what you are saying is, if we are with you on constructive refusal, it will mean that the fact that the Equality Court has not determined remedy will not be, the Equality Court will no longer have the right to determine remedy. This court must determine remedy.
That is correct, Justice Mhlantla. In our submission, the Equality Court has determined the remedy by its refusal to hear it. That amounts to a constructive refusal of a remedy, and it entitles the applicants to apply to this court on appeal.
Mr. Hawthorne, my understanding of new clicks is that an appeal court is willing to make use in very special circumstances of constructive refusal for the purposes of exercising its own jurisdiction. But I am not certain that I've seen a case in which an appellate court uses the doctrine for the purpose of intervening in the jurisdiction of a lower court where the matter is still in media res. There's no res judicata. So perhaps you could tell us what your submissions are as to where an appellate court, and here the Constitutional Court, enjoys the power to intervene jurisdictionally in the exercise of a lower court's jurisdiction, because constructive refusal is in effect to treat a case in another court as having resulted in a particular outcome. And that's really an exercise of that court's jurisdiction.
Justice Unterhalter, our submission would be that the constructive refusal of a remedy, if we are correct in our submission that there has been a constructive refusal of a remedy on a part of the equality of court, that amounts to a determination of the issues, and that amounts to the court becoming functus officio with regard to those issues. Which
yes,
means,
but the question is, that's a finding that in effect is being attributed to the equality court. And that is then an appellate court making that finding in respect of the equality court, and hence exercising its jurisdiction. My question is a powers question. How does an appeal court enjoy that power?
Justice Unterhalter, my response to that would be in terms of the SABC principles, that the court in that case established that it would, in appropriate circumstances, and it didn't in the circumstances of that case, in terms of its inherent power, in terms of section 173 of the Constitution, have the ability to prescribe to the SCA how to regulate its procedures. And so
wouldn't that simply be, at most for your case, a competence that this court would enjoy to direct the equality court to adopt a procedure such as hearing the matter in a reasonable time, not to determine the matter and exercise the substantive jurisdiction of that court?
Justice Unterhalter, in our submission, that if there is a finding of functus officio, that the applicant or the litigant who has become functus officio, who contends that the matter has become functus officio, has a right of access to court. And there's no way that that right...
Functus officio is an objective question that has to come about, and it can only come about through a particular intervention. And I'm still struggling to understand the power of an appellate court to exercise that power so as to bring functus officio about.
Well, it's a matter of if the court is, let's be specific here, if the equality court is not setting the matter down so that there can be a finding, then there's no alternative available to the litigant in those circumstances, but to approach a superior court for such a finding. It's a matter, it follows from first principles, from the Harris principles. If there's a right, there must be a remedy.
But my last question isn't really the best case that you have is to say that there is a competence that exists in an appeal court under 173 to make certain directory orders as to procedures to be followed to complete the proceedings in the lower court.
Justice Unterhalter, that might be the normal remedy that would be exercised by a court in those circumstances. That if one has regard to the facts of this matter, where the applicants are requesting this court to determine it, if one looks at the position of the SAPS respondents, their case is that the declaratory orders granted by the Equality Court are a sufficient remedy, and their case is that there's nothing further is required for apart.
Excuse me, Mr. Hawthorne. Excuse me. Excuse me, Mr. Hawthorne. For this court to entertain any prospect of hearing this matter, there are certain jurisdictional facts that you must satisfy. Among the others is the issues that my brother presiding canvassed with you at the beginning of this hearing, i.e. that you appeal against the order. And I don't seem to have heard you clearly what you are seeking us to do. And if you are appealing against an order, which order in particular that you are appealing against? I'm saying this in the light of uncompleted or unterminated proceedings. Further on, you seek to rely on Walha's case. My reading and understanding of that case is that it's against you. The only facts that you extrapolated from that decision were three. One, the exceptions relates to rare cases, which you have not told us why you think the facts of this case are rare. Two, that there would be a grave injustice. Three, that there would be a failure of justice. My sister Mhlanhla put it to you that Walhas and other cases that followed it discourages litigation on a piecemeal basis. So what you are seeking us to do now, and following from the debate that you had with my brother Unterhalter, is this not the kind of a situation where you are urging upon us to decide this matter on a piecemeal basis? This is a fact-laden issue, and if it's a fact-laden issue, the question that follows is whether an appellate court like ours has jurisdiction to entertain any fact-laden issue. The answer obviously is no. Now, for you to be able to urge upon us to issue any directions to the Equality Court, firstly, you have to satisfy us that indeed there was constructive refusal. One. Two, and that the threshold that is in NewClicks has to be developed and extended. And on the facts of this case, unless if I'm wrong, speaking for myself, I don't see any basis for any extension nor development of the NewClicks cases. The facts in NewClicks and the facts in this case, my prima facie view, subject to your argument, is that clearly distinguishable. I thought I should put those propositions to you. There are more propositions that I want to put to you. But if you don't surmount this first hurdle, I think there is a problem. Thank you.
Justice Matopo, a number of...
Sorry, can I just finish one last aspect before you respond? Is this not a case? Well, obviously it's tied up to the constructive refusal. Is this not a case where the Equality Court should be given an opportunity to deal with the merits, not the merits rather, the remedy that is outstanding? Now, you are saying to us, on the facts before us, we are in as good a position as the Equality Court to pronounce on the remedy. I don't know what would be the basis for that. When I read the papers and also your founding affidavit and the replying affidavit, where the respondent says they have revised their policies, which you found laudable. And one doesn't know now, as a court of appeal, what are we to make of that? Thank you.
Justice Matopo, there are a number of issues that have been raised by your question, and I'll try and deal with them in turn. The first issue that you raised was which order, where is the order that the applicants seek to appeal against? And in that regard, our submissions, we work from first principles. If the applicants have a right of access to court, which it's clear that they do have, that right is infringed. It's clear from the New Clicks principles. It's infringed in circumstances where there has been a delay in determining an application for leave to appeal. And our submission would be that it must follow, as a matter of logic, that if there's a right of access to court, it must follow, as the SCA said in New Clicks, that without a decision in a case, that right is meaningless. So in principle, that right applies to, is infringed in circumstances where there's a failure to set a matter down for a hearing. And they'll get to a point, it must be, and we would say that as a matter of principle, there must be a point which arrives, and whether the applicants have come to this court prematurely is a different issue which we can debate in turn. But we submit that as a matter of principle, there must be a point at which a failure to set down a matter such as a remedy hearing will amount to a constructive refusal of that remedy. And if that point has been reached, then it follows from the Harris principles that if that right has been infringed, there must be a remedy. And if it requires this court to determine a matter which there's no order in the Equality Court, that must follow from the fact that there has been a constructive refusal and the applicant's rights have been infringed, and they must have a remedy. That remedy is not going to come because of the failure to set the matter down from the Equality Court, and there's no alternative but to obtain that remedy from the Court of Appeal.
Can I interrupt you? Is this not one of the cases that has the hallmarks of an impatient litigant? I understand the frustrations that may have occurred in trying to secure a date. But as you and I would know, impatience does not grant you access to a higher court on these facts.
Justice, we submit that, in that regard, we submit that if one has regard firstly to the importance of the rights at stake and the fact that they implicate, they go to the heart of the objectives that the Equality Act seeks to achieve, and our submission is that this application should not be argued as if it's divorced from the Equality Act, the principles of that act. So they're of fundamental importance for potentially millions of South Africans. And
Mr. Houghton, sorry to interrupt you. I'm not asking a new question, but when you address Justice Matopo's last question, can you also deal with the timelines that the respondent has outlined for us? And I think that those timelines are important because the first determination we have to make is that there was a constructive refusal. Now, if you look at those timelines, and I've got them here, that yes, the judgment was in December 2018. But according to the respondent, the parties only started engaging 6 months later. And then the parties approached the court 9 months later on the 18th September 2019. And then what also struck me was the fact that it seems to me that the earliest date that was available for all the parties was December 2020. Now, when I look at December 2020 and I look at the approach to this court on the 10th of April 2021, then I wonder whether, in fact, there are exceptional circumstances in order for us to arrive at a conclusion that there was a constructive refusal. So I don't mean to interrupt your questioning, I mean your response to Justice Matopo, but I thought that perhaps in an attempt to respond to Justice Matopo's last question, you could also address this, because my first problem is whether in fact there was a constructive refusal.
Justice Chikri, before I address the timelines, and I'll take the court through the timelines that are applicable. I just want to respond to one of the aspects that was raised by Justice Matopo, and that was that the question before the court is a fact-laden issue. And our submission is that it's not that one needs to distinguish between the question of what remedy is to be given, and that's the fundamental issue at stake in the remedy hearing, is whether the declaratory orders granted by the Equality Court in December 2018 constitute sufficient relief. And that is not a fact-laden issue. That is a question of whether or not the procedure that the SAPs have put in place is sufficient, or whether the applicants are entitled to more in terms of supervision. And that the facts necessary to determine that are before this court. One needs to
excuse me, Mr. Houghton. That's my last interruption to you. I promise. The parties subsequent to the order, they sought to agree on something on the remedy. The reason why you are here and everybody is here is because parties could not agree on the remedy. And if the Equality Court could agree on the remedy, it ought to have done so. There must have been circumstances that made it impossible for that court to give an order on the merits as well as on the remedy. Now, my biggest problem is now, if you seek to persuade us, as you are trying to consider the remedy, which the Equality Court then and the parties then could not agree to, and they had to go and do their homeworks in order to submit or do whatever, for lack of a better word, put whatever sufficient facts were necessary before that court to enable it to arrive at a decision on remedy. Now, if you want us to do that, what do we have that is different from the Equality Court? What is new that has been placed before us? So I'm not trying to interrupt you. I say, as you round up all other factors, please consider this submission. I thought I should raise it before I forget. I'm sorry to interrupt you.
Justice Matopo, that what you're putting to us is we would endorse that wholeheartedly. We submit that the interests of justice are strongly in favor of this litigation being put to bed without having to go for another further hearing in the Equality Court to determine the issue, which is at the heart of it, is the issue is the declaratory relief that was granted by
Mr. Hawthorne, I understood the question more to be a curveball than a lifeline. Maybe I misunderstood it.
No, Justice Madlanga, within it, we would submit that the seeds of the essence of the applicant's argument there is that the basic issue to be determined is a straightforward one. Are those declaratory orders sufficient relief for the applicants? And we submit that it's a simple issue. It doesn't involve disputes of fact that would, or complex issues which would arise if a supervisory order were put in place and it would be necessary for the court to determine whether the discrimination has been addressed and eliminated. Those are complex issues which would arise and would need to be determined if a supervisory order is in place, but that is down the line. For the question of whether or not any relief further than the declaratory orders is required the Equality Court was in a position to determine that when the matter was argued prior to its judgment in 2018. It could have easily been determined on the facts as they stood at that time. So our submission would be that it's strongly in the interest of justice for this protracted litigation to be put to bed and to have to go back to the Equality Court in another year's time for them to make a finding as to whether or not the December 2018 orders were sufficient or whether something more is required in the form of supervisory relief is not in the interests of the parties. It's not in the interests of the courts, which will be further burdened with another hearing of this application. And it's certainly not in the interests of the applicant, which is, it's on record that they are organizations of limited means, and they've committed very substantial financial resources to engaging in this litigation. So,
Mr. Hawthorne, may I?
Before my brother Justice Majid comes in, may I ask you to please grapple with the issue of the timeline that my sister Justice Chikri raised with you? Sorry, my brother Justice Majid.
Justice, with regard to the timelines, our submission would be that following the judgment of the Equality Court in December 2018, one can break what followed there into a number of phases. And the first phase would be the appeal phase, which took place between January and April 2019. And again, it's clear that in the applicant's founding affidavit, they said they placed on record that in agreeing to withdraw their cross appeal, their application, the applicants were motivated by two considerations. Firstly, the urgent need to revise the human resource allocation system and to avoid delays in that process by going through appeals and further litigation. And also the view was expressed that the cross appeal was potentially premature. So that was the first phase, that there were appeals instituted and negotiations took place, and then those were withdrawn. The next phase that one has to deal with is a negotiation phase between May and September 2019. And in the meeting that took place in terms of the court order on the 12th of July, SAPS advised the applicants that they were in the process of formulating a plan to remedy the deficiencies accepted by the court. And this plan would be presented to the National Commissioner for approval by the end of August that year, and then subsequently to the applicants. And when that plan was made available to the applicants, it became clear that it was the IRS document, it was a generalized human resources strategy. It did not deal with the issues identified by the court. It made only passing reference to the court judgment, and it certainly was not the plan that was promised by SAPS at the meeting to remedy the deficiencies identified by the court. It was a generalized document, and in it, it stated that the timeline for the analysis of the court ruling was March 2020 and ongoing. They hadn't even got to the point of doing an analysis of the court document. And as a result of that generalized document, the failure to present a plan as they had undertaken to do.
Justice Chikri, is this addressing your question?
It's in a roundabout way, Justice.
I'm sorry to put a question.
I'm hoping. No, it's a fair question, and I just think perhaps Mr. Hawthorne is supplementing the timeline Respondent has provided to us.
My apologies, Mr. Hawthorne. My apologies.
But like I think it's important to place the engagements with the court after September 2020 in the context of what had led up to them, and the fact that the applicants had repeatedly stressed the urgency of the matter, the urgent need for a remedy, and taken all the steps that they could do to have the matter finalized without further delay. And then,
may I at this point say that your 45 minutes is up, but I know, of course, you did not even begin to present argument in the manner you wanted to. But of course, we've been engaging you on some of the issues you would have to address anyway. But I'm aware that you did not get to even have a foot in, as it were. But the 45 minutes is up. How much more time do you ask for?
Justice Madlanga, if Justice Majid can put his question and I can respond to that, then I would appreciate that.
Perhaps before my brother Majid does respond to you, I'm interested to know when was the first date, when was the first occasion, because what you've shared with us thus far is the engagements within the parties and so on. So when was the first date on which the parties approached the court and asked it to determine remedy? And when were the parties available for the matter to be set down? If you can just assist me with those two.
Justice Chikri, on the 6th of August 2019, the Equality Court made an order to the effect that if the parties were unable to agree on a remedy, the court would set the matter down for argument on the earliest suitable date. So it's clear that the court acknowledged that it was a matter of urgency. Then, beginning of September that year, the IRS document, which was effectively squashed the negotiations. It was certainly not what was promised to the applicants or what the applicants were expecting. And it was at that point, it was after that document was received. On 18 September 2019, SJC's attorney addressed a letter to the presiding judges and put on record that the document received was not a plan, and requested the court at that point to set the matter down for a hearing as soon as possible to avoid any further delays in concluding the matter. And in that letter, the applicants gave a range of alternative dates in late 2019 and early 2020 when they would be available for the hearing of that matter. So that was 18 September 2019. That's at paragraph 65 of the applicant's founding affidavit. And then in paragraph 66 of the affidavit, it's recorded that the judges responded to the correspondence and said that they would revert to the applicants with regard.
Excuse me, Mr. Hopper. Ultimately, what was the date that was suitable to both counsel?
Well, Justice Chiefly, the dates were proposed by the applicants in September 2019. Then in later that month, the judges stated that they would revert to the applicants with regard to the date suggested by the letter. There was no, the justices didn't revert to the applicants. Then later that year, in December, the applicants wrote to the court again and requested an urgent meeting. That meeting happened in January 2020, at the end of January 2020. And at that meeting, the justices advised that they had difficulties with their diaries as a result of them receiving appointments to act in the SCA. And they said that they would be available between the 2nd and the 12th of March that year. And then there were negotiations between the parties and the SAPS's counsel were not available on the dates proposed by the applicant's counsel. I can't remember, but a number of those dates in the window that had been made available by the justices were suitable to the applicants were available, but SAPS was not available on any of those dates. And then further negotiations took place, and the applicants, in the eagerness to have the matter resolved, even proposed that the matter be heard over a weekend in order to bring the matter to finality. And that was early in 2020. That also was not acceptable to SAPS's counsel. And then the process that was followed was that Justice Delamo stated that the matter would be determined on the papers in August that year. And then
that was now August 2020.
That was August 2020. And then Justice Delamo, after having, it's not clear what the reason was, but he took a decision that it would not be decided on the papers. The SAPS filed a further affidavit by General Mbeki in August. And then from September 2020, the engagement with the justices began on the part of the applicants, and that's dealt with in detail. And our submission was that nothing, the applicants had engaged with
Perhaps the point, because I don't want to be unfair to my colleagues, specifically Justice Majid has been waiting to put his question to you. The reason I ask this question is about the requirement of exceptional circumstances. And when I looked at the delay from the date on which this matter, you were told that this matter would be entertained, bearing in mind that before that period, the deliberations were between the parties themselves. Because in order to find that there's constructive refusal, unless I'm wrong, we have to say that it is the court that delayed or did not give you the remedy. But if between the period between December and that last date, when you felt that you can't wait anymore, the delay was not on the door of the court alone, but it was between the parties themselves trying to craft an appropriate remedy. I wonder whether under those circumstances, we can make a finding that there was constructive refusal by the court. And also whether we should ignore the fact that during that period, there was a lengthy period during which the parties were engaging each other in order to find an alternative remedy. So this is where my question is coming from, really.
Justice, thank you, Justice Chikri. I would just stress that that engagement with SAPS on the part of the applicants was motivated by a desire to obtain a speedy remedy without the need for further litigation. That the context was the applicants proposed certain dates to the court in September 2019. The court said that it would revert to the applicants in respect of those dates, and it did not do so. Then a year later, Justice Delamo requested the parties to make an election. And in its response, the applicants requested it was mid-September 2020, they requested a date the matter be heard as soon as possible. Then the applicants followed up in October with a telephone call to the Justice's registrar, and she she said that there was no decision concerning the composition of the court, and she undertook to revert as soon as there was a decision. The applicants followed up again and the following month on the 18th of November with another letter and requesting a hearing before the end of the fourth term of 2020. This was followed up.
Mr. Houghton, sorry. I think the dates are there in the papers. So the period that we have to take into account in order to determine whether there was constructive refusal is from September 2020 up to 10 April 2021 when you launched this application.
Justice Chikri,
because that is the period during which the court then did not give you a date.
Justice, that must be seen in the context of dates being proposed by the applicants in September 2019, and the court stating that they would revert in respect to the suitability of those dates and not doing so. So that's why it's important to put the events which took place after September 2020 in that context. And
Mrs. Madlanga, thank you. I'm covered.
Thank you, Mrs. Justice Majid.
Thank you. Mr. Hawthorne, just to preface my question, I share the concern enunciated by several colleagues about this unprecedented step you're asking to take to intervene proceedings, unterminated proceedings in the High Court. As an apex court, I think any appellate court should be very, very hesitant to intrude on the domain of lower courts in these unterminated proceedings. Be that as it may, I want to take you to an aspect dealt with by Justice Tiki to some extent, and it is this. The respondents pointed out, first to third respondents anyway, pointed out that they offered to you in correspondence in April 2021, the 30th of April to be more precise, to have a joint approach to the Judge President Hlophe to resolve the difficulty that had arisen in this case. But you rebuffed them, and I'm asking this question in the context of what New Clicks sets as a standard for finding constructive refusal. One of the things that New Clicks says in paragraph 70 or 71 is that it must be a measure of last resort. So I'm probing whether this is true in this case. So you rebuff this approach of suggest a joint approach. And what is important for my question is your response. You say, in your response, rejecting that, you say, well, the Equality Court is functus officio and lacks a jurisdiction. Is that a correct summary? Because I just want to check before I ask the question. Do you accept that you said, well, the Equality Court is functus officio?
Yes, Justice Majid, our case is quite simply that whether or not there was a constructive refusal of a remedy is to be determined at the date on which the application to this court was launched.
Let me continue. I just wanted to check whether I've got my facts right. So the question is this: having rebuffed that joint request approach or suggestion, you say the court is functus officio, but it is not, isn't it? It's different than new clicks where there had been a judgment of the High Court, a majority and a minority judgment, and that judgment was final on the orders as far as the relief sought and the remedy sought, which is not the case here. The remedy hasn't been decided, and so it's distinguishable at least on that score. But even further than that, if we are going to be against you against the relief you seek in primary relief, and we're against you against the first alternative, but we are for you with a second alternative, which is to remand the matter, then the functus officio argument falls away completely, because you yourself asked for rebuttal with appropriate direction. So it seems to me that saying the High Court is functus officio, the Equality Court, sorry, is functus officio, is off the mark.
Justice Majid, with regard to the direct access relief, that is sought in the alternative to the constructive refusal of a remedy. And we stated explicitly that the constructive refusal of a remedy there was little precedent for such relief, and we accepted that the advice given to the applicants by their legal representatives in that regard might be wrong. And that was the reason why we didn't approach the SCA, because it's an issue on which there was little precedent. But with regard to what was put to me, that the applicants rebuffed the approach made by the SAPS in late April, that we submit that it wasn't, we didn't rebuff them. The applicants had no alternative. Either we had made out a case for constructive refusal of a remedy when we launched the application at the beginning of April, or we had not. And what happened, and if there was a constructive refusal of the remedy when we launched, then we were entitled to the relief, and what we had, what the applicants did thereafter wouldn't affect that. And in any event, the applicants had burnt their bridges with the Equality Court by that stage. That one can envisage that the Equality Court, the Judge President and Justice Delamo had been put to terms to respond to the request to set the matter down. They had not responded to being put to terms. And then the applicants had launched the application to this court at that point. And one can envisage going into the Judge President's chambers and him asking, well, you know, is it April the 1st today? I've read your affidavit, which was served on the Judge President, and you said that this matter has already been constructively determined by the Equality Court. And if that's the case, then what are you doing coming here with SAPS and asking me to set the matter down at this stage? Go and seek your relief in the Constitutional Court. You've made your bed and you must go and lie on it. And we would have had no answer to that difficulty put to it if it had been put to us. So
you see, Mr. Hawthorne, what bothers me is that the timelines, as I see it, is exactly as those suggested by my sister Tiki, because we must calculate it from September 2020, I think, when the approaches started being made. And it seemed to me to be eminently more reasonable to have taken up that suggestion and approached the Judge President together with this request, rather than to come to this court to ask for this unprecedented relief in unterminated proceedings.
And as you respond, I hope I will not derail Mr. Hawthorne from the substance of your question, my brother. But as you respond, please bear in mind that when we determine matters here, the issue of the interests of justice weighs very heavily. And so at the heart of what my brother is raising with you is the question whether when your colleagues are saying, no, 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 please, whatever the stage at which we are now may be, let us just approach the judge president together. So as part of your response, just consider that that does go to the question of the interest of justice as well.
Yeah, that's absolutely right. Thank you, my brother.
Justices Majid and Madlanga, I've got nothing substantial to add to what has been put already, is that we've made out a case before this court that there was a constructive refusal of a remedy on the 11th or 12th of April 2021. And that is either correct or it's not. If we are correct, then yes, going to the judge president later that month, it makes no sense because the remedy has already been refused.
Thank you. May I at this stage, Mr. Hawthorne, say that you have had 18 minutes more than the time I allocated. May I at this stage ask how much more time do you want?
Justice Madlanga, I've got nothing further unless there are further questions. Yes. Members of the court would like to put
yes.
to.
Justice Madlanga, if I may.
Could I just ask a last question? My second and last question is this, please, Mr. Hawthorne. Do you accept that the relief you asked for in terms of paragraph 2 of that order, I think it's 2 of the order of the Equality Court, is not only partially moot, but is completely moot in the sense that the THHR has now been made available, and I think you correctly concede that it is a significant step forward in submitting what was required of it in terms of the relief you sought in terms of the national relief. So do you accept that part of the application at least is moot?
Justice Majid, what our position would be that the need for, we didn't abandon the application for leave to appeal against the paragraph 2 of the order. What happened as a result of the answering affidavit that was filed by SAPS was it became apparent that the issues that needed to be determined for purposes that prompted that launching that application for leave to appeal were no longer in dispute between the parties, and the need for that relief accordingly fell away. So it wasn't a matter of us abandoning it, it was SAPS conceding that the issues were no longer in dispute. They have accepted that they need to revise the...
Sorry, Mr. Hawthorne, I think the question was, do you accept that it's moot? Whatever the reasons may have been historically.
Justice Kolapton, I'm reluctant to make that concession in view of the fact that SAPS has not come up with a definitive plan, that the draft revision of the THRR is no more than a draft, and there's no timeline has been committed to as to when the National Commissioner and the top management of the SAPS will make a decision on whether or not they're going to endorse the draft which was presented to this court. So,
Mr. Hawthorne, sorry to interrupt you, but it does bother me. You appear to vacillate in your papers on this on the answer to this question I'm asking, and you still appear to do so. It seems to me that you've rightly conceded throughout the papers that what you seek is not for this court or any other court or the Equality Court to prescribe to SAPS how they should implement these measures, because that's a policy-laden issue as to how they implement and so on. But now they've taken the step, and you concede that the need for the relief has fallen away. Isn't that the complete answer, that therefore the matter is moot? You can't seek us now to if that's what you want to have to sort of supervise SAPS and to peer over their shoulders to see how how far they implement this plan and how fast. Surely it is moot, not so?
Justice Majid, we agree. We've always made it clear that it's not up to us, the applicants, to prescribe to SAPS as to how they should remedy the THR, the allocation system. But we submit that whether or not anything more than the declaratory orders is required is certainly not a moot question, and that we've made out the case, and I'm not going to repeat what we've said already, but we submit that the declaratory orders alone will certainly not constitute an effective remedy, given the complexity of the process, and that even if the SAPS tries in a bona fide fashion to implement the revisions which they put before the court to the THRR, it's not clear what the effect of the revised THRR will be on the actual discriminatory allocation of human resources. And fundamentally, that what we've got is no more than a draft, which hasn't formally been approved by the top management of SAPS. It's a draft, and we're not told what will happen in the event that the National Commissioner decides not to approve. So where would that leave us in terms of having a remedy?
Yeah, thank you, Mr. Hawthorne. Thank you, Justice Madlanga.
Justice Madlanga, if I may, please. Just in a way, following up on that exchange between yourself and Justice Majid, Mr. Hawthorne, if I understand the applicant's position on the THRR is that it takes significant steps to address the unfair discrimination. I think that's clear from the stance of the applicant. The concern of the applicant is that the plan has not been adopted and doesn't make provision for a date for rolling out. Is that correct?
Justice Thrr, the concerns of the applicants go further than that. If one has a close reading of the document that is annexed to the SAPS answering affidavit in this court, it discloses that at paragraph 634, it says phase 4 is currently where SAPS is at. That's with regard to the revision process. And it goes on to state on that same page that a modeling and enhancing criteria was signed off on the 31st of March 2017. So the process, that the draft that one is prepared and is before the court, has a long prehistory which wasn't disclosed by SAPS in any of its documents that it submitted to the Equality Court in September 2019, or the affidavit of General Mbeki in August 2020. And then at page 634 of the document, it states that following the Equality Court judgment, a task team was established and met in March and May 2019. That's clear from the record. Then on the following page, it says that in October 2019, the task team met and reviewed progress on the review in detail, and the final draft was adopted for presentation to the National Commissioner and top management. And that was in October 2019. And yet General Mbeki, in his affidavit to the Equality Court in August 2020, makes no mention of this, the fact that a final draft of the THRR revision plan has been adopted almost a year ago. And then if one continues that at page 638, it says the revised THRR will be rolled out in the 2021-2022 financial year. Now the SAPS financial year ends in March. So according to the document that the SAPS has presented to the court, that the revised THRR should have already been rolled out for a year in the pilot provinces by the end of March this year. So what we can take from this document is that the process that SAPS has undertaken to revise the THRR it's run into difficulties. That a final draft was ready in October 2019, and somehow the progression has stalled since then, and we know that it hasn't been endorsed, and there's no explanation from SAPS as to what the problems were and where we are in the process of revising the document. So our submission in that regard would be that all is not well with regard to the revision process, and an explanation is required from SAPS as to what the difficulties are and why it's not running smoothly.
Yes, we're dealing now with remedy, and the first question I asked also related to that. On the assumption, of course, that the applicant gets over the jurisdiction hurdle. What you have just pointed out, Mr. Hawthorne, doesn't that militate against a supervisory order, but instead towards a mandatory order, that if the court was with you? Because we're not dealing here with a recalcitrant SAPS. We're dealing with the SAPS who wants to remedy the situation. In those circumstances, would it be justified to give a supervisory order?
Justice Thrr, we submit that if the relief is restricted to declaratory orders and a mandatory order, and there's no supervision, the difficulty with that is that the applicants will be, firstly, completely in the dark, firstly as to with regard to what steps are taken, and secondly with regard to the effect of those steps on the actual discriminatory allocation of resources identified by the Equality Court in its judgment. And it's for those reasons, because of the complexity of those issues, that a supervisory order is, we submit necessary. That a mandatory order would take us no further, because there would be no way of enforcing it in the absence of reports to the court with regard to the progress being made.
If we are with you that a supervisory order is necessary, wouldn't the Equality Court be best placed to supervise that order? And shouldn't this court, if it was minded to grant such an order, vest the Equality Court with those supervisory orders? Supervisory powers, I mean.
Justice Thrr, we accept that in our order we seek relief that this court supervise it. We accept that would be a resource-intensive process, that one would require 11 judges to do a job that could easily be done by one judge. With regard to the Equality Court supervising it, I don't have instructions to concede to that, but it's self-evident that would be a more efficient way of dealing with it, particularly in light of sort of considerations that arose in the PECO case.
My last question, Mr. Hawthorne, relates to the national versus the Western Cape relief. Is the applicant pursuing national relief, or what has been classified as the national relief? And if yes, is it entitled to do so in this court?
Justice Thrr, the applicant certainly pursues the national relief. That it's always been such relief has always been sought. If one has a look at paragraph 2 of the Equality Court's order, it's our submission that the court has identified the system for allocation of human resources as being discriminatory. And
I'm sorry to interrupt you, Mr. Hawthorne. It's just in the interest of time. Didn't the Equality Court limit that to the Western Cape? That there was no finding in regards to nationally that there was this discrimination. And that hasn't, if I'm correct, that hasn't been appealed against by the applicant.
Justice Zerana, if I can just take the court to the terms of the order at page 143, paragraph 1, it's stated, it is declared that the allocation of police human resources in the Western Cape unfairly discriminates against Black and poor people on the basis of race and poverty. So that is clear that that is limited to Western Cape. In paragraph 2 is not a model of clarity. It says, it is declared that the system employed by SAPS to determine the allocation of police human resources, in the words, insofar as it has been shown to be the case in the Western Cape province, unfairly discriminates against Black and poor people on the basis of race and poverty. And our submission, if that paragraph is read in the light of the findings in the judgment, and in this regard, I refer to paragraphs 75 and 76 of the judgment in particular, where it is clear that it's the THRR which is identified as the cause of the discrimination. Our submission would be that one cannot grant relief, one cannot remedy the declaratory relief granted in paragraph 2 of the court order unless one...
The specific finding in paragraph 1 of the order relates to the application of the THRR in the Western Cape, not on a national basis. So in the same way that you contend or argue that we should read paragraph 2 of the order with paragraph 75 and 76, that could actually go against the applicant as well on the other side.
Justice Duran, we submit that if one has a look at the relief as it initially formulated, that the prayer in our notice of motion in the Equality Court, which resulted in paragraph 1 of the court's order, was dealing with the actual allocation of human resources. Then prayer 2 follows from a prayer in the notice of motion, sorry, paragraph 2 of the order follows from a prayer in the notice of motion, seeking to have the system for the allocation of resources.
Mr. Hawthorne, excuse me to interrupt you. You don't appeal the reasons, you appeal the order. If you look at paragraph 1 and 2, nothing is said about national relief. The law is clear on that point. If there is any appeal on national relief, it ought to have been to say, we asked for a relief on a national scale. It was not granted. We are appealing it, but it's not there. Why do we have to entertain the reason? A court can say whatever it likes, but what remains at the end of the day is the order that is being appealed against, not the reasons. You may say anything that you want to say. It may say anything that it wants to say. What my sister is putting to you is paragraph 1 and paragraph 2 relates to the Western Province. Now you want us to read paragraph 2 with the reasons. It doesn't work that way.
Justice Matopo, our submission would be that paragraph 2 of the order is not a model of clarity, and that in order to interpret it, in order to understand it, one needs to have regard to the judgment. And
Mr. Hawthorne, why don't you look at paragraph 77?
77.
Which made it plain that you can't extrapolate from the Western Cape to the rest of the country.
Justice Unterhalter, that what happened is that the applicants launched this application in this court in which they sought leave to appeal against paragraph 2. And in view of the need, as a precautionary measure, in order to make certain that the THRR system was revised. And once it became clear from the evidence before this court that the need to reform the THRR, which has effect nationally, was no longer in dispute, then the need for that
But you may have decided that on pragmatic grounds, but now that you're seeking the remedies that you are, we have to deal with the orders as they exist, even as understood in the light of the reasons that are provided, and those make it plain that it's confined to the Western Cape. So don't you have to live with that? That's the choice that you've made.
No, Justice Onthalter, with respect, that is not the case, because our submission would be it's not possible to remedy the Western Cape discrimination without revising the THRR. And if the SAPS had come to court and made out a case that is along the lines of that, well, we can remedy the Western Cape discrimination through Section 12.3 reallocations on the part of the provincial commissioner, then that would be one thing, but that's not the situation.
But then you had to appeal the orders.
Well, we haven't abandoned
you can't do it both ways. Either a national remedy alone suffices, in which event you must upset and appeal the orders that you've received the benefit of because they don't go far enough, or you must live with the orders. And to the extent that we have a basis for entertaining the remedies that you wish us to do, we're confined to the Western Cape because the only discrimination that was found was in the Western Cape.
Justice Onthalter, we submit that applying the principles in the Hoërskool Ermelo case, that one needs to engage with the substance of the issue in dispute and given a remedy from that. And given the ambiguity of paragraph 2 of the order, that it says that the system for allocation of human resources is discriminatory insofar as been shown to be the case in the Western Cape. It's clear that the system is discriminatory. If one has regard to what the components are of that system, it's the THHR is the first component. The second is the actual allocations, which fixed establishment, which is the THRR subject to budgetary restraints. And then the third component would be the Section 12.3 allocations, which SAPS has not tried to make out a case that they can remedy the problems identified.
Holden, could I just ask you one final question, which is just about the supervisory order that you seek? It's sought in very wide and general terms and seems to be a displacement of the actual remedial questions that would need to be answered, which is to say, do the proposed revisions to the THRR meet the requirements of the discrimination that have been found or not, which appears to be a fact-heavy, or at least engages factual and evidential questions, probably also of an expert kind. Why should that be done under the guise of a supervisory order rather than done substantively as to what is the tailored remedy for the discrimination that has been found, which is precisely what an equality court is there to do and not an appellate court?
Justice Onthalter, we made it clear that we're not wedded to the formulation of the supervisory order that is set out in our notice of motion. And if SAPS had been prepared to engage on the terms of the order and propose alternatives, we would have been happy to do so. But what we have done in formulating that order, it's been based on the recommendations of the Khayelitsha Commission of Inquiry. If this court is not inclined to engage in the supervision insofar as a supervisory order were to be granted and were to to suggest, to find that the Equality Court should engage in a process either through a structural interdict or another equivalent means to ensure that there's an effective remedy. We would be hard pressed to object to that, although I've got no instructions to agree to in order that the Equality Court supervise the remedy process.
Thank you for the indulgence, Justice Madlanga.
You're welcome, my sister. Mr. Hawthorne, thank you very much for your submissions. Let us adjourn until 11:45. Court adjourn.
Please note that during adjournment, you are welcome to switch off your videos and mute your microphone, and then you may rejoin with the video and sound when the hearing recommences at 11:45. Should you exit, you may use the same link to rejoin the hearing. Justices of the Constitutional Court, all counsel is online.
Thank you, Mr. Kamisa. Colleagues.
Justice Madlanga, I'm trying to restart my video. It says the host has stopped my video. Can the host please restore my video link? Thank you.
Thank you, my brother. Other colleagues? Thank you. Thank you. Colleagues, may we start? Are you all behind your screens? Thank you. Yes, Ms. Christians.
Thank you, Justice Madlanga. The Women's Legal Centre's position in this court is to show that there cannot be a meaningful overhaul of the methodology or formulae for allocating police human resources without an express consideration of whether such an overhaul adequately takes into account the scourge of violence against women in this country. Commendably, after the Equality Court proceeding, SAPS has taken steps to revise the THRR to address the findings of the Khayelitsha Commission and the Equality Court. However, and we submit regrettably, SAPS has limited its revision to only deal with the findings of those fora. This despite the states, including SAPS's unequivocal acknowledgements that violence against women in this country must be addressed. Particularly in light of the state's stance on the need to address the prevalence of violence against women since the Equality Court judgment, the WLC implores this court to consider the additional evidence it has placed before this court when it considers the factors that must be taken into account when the THRR is further revised. That statement, of course, is on the assumption that this court is minded to delve into the merits of the remedy that the applicant seeks. The additional evidence that the WLC presents comes from official state sources. We submit it is irrefutable and, importantly, has not been challenged by any of the parties in this court. In fact, the state's unequivocal and public undertaking to address the scourge of violence against women is so notorious that we submit this court could actually take judicial notice thereof. But going further than taking judicial notice of the fact, what the WLC seeks to do by introducing the additional evidence is draw this court's attention to the relevant material released by the state after the Equality Court's judgment was delivered, but before the THRR was presented to this court. And that material, which again I submit is uncontroverted, illustrates that SAPS, despite being aware of and being part of the state's initiatives to address violence against women, has not taken that responsibility into account in its process of revising the allocation of police human resources. And based on the executive summary of the revised THRR, the only discernible reason for the omission is that SAPS has not been ordered by a court to take violence against women into account. And we submit this is plainly irrational. In addition to seeking to adduce additional evidence, the WLC proposes slightly broader relief than that sought by the applicants. And I'll deal with that issue briefly. Although the applicants have focused their case on violent crimes generally and discrimination on the basis of poverty and race, it is not insignificant that these very proceedings and the proceedings before the Khayelitsha Commission and the Equality Court were precipitated by the violent murders of 3 women. Those are Lorna Mlofana, Nandipa Makeke, and Zoliswa Nkonyana. And in the founding affidavit of the applicants, the deponent confirms that the initial complaint to the Premier of the Western Cape, which led to the Khayelitsha Commission, highlighted the routine manner in which the rights of community members were violated and the impact of high crime rates on residents, particularly children and women. The deponent also reveals that particularly children, women, and other vulnerable members of the community fall victim to violent crime while performing daily activities such as collecting water or using the toilet. And so while the WLC fully aligns itself with the relief sought by the applicants, it proposes some adjustments or additions to the relief proposed by the applicants, specifically in light of gender considerations. The Equality Court judgment confirms that the WLC's evidence and submissions in that court also focused on how and why the allocation of police resources results in unfair discrimination on the basis of gender. Regrettably, however, the Equality Court downplayed the importance of the WLC's evidence because, according to it, the unfair discrimination challenge before it was on the basis of race and poverty and not gender. And it's therefore necessary for me to deal shortly with why the extended relief sought by the WLC is competent and why this court, or indeed the Equality Court, was empowered to grant it. And the principles relate to additional evidence and relief sought by amici curiae in proceedings. And this court will recall that the WLC was admitted as an amicus in the Equality Court. In Constitutional Law of South Africa, Jeff Bandlender, SC, provides a useful discussion on how the role of amici curiae has developed in our post-constitutional jurisprudence. And unlike the traditional position, where an amicus does not represent a particular interest or point of view, an amicus in constitutional order is often a non-party that requests the right to intervene so that it might advance a particular legal position which it itself has chosen. And one of the justifications for this approach is because constitutional litigation often affects a range of people and interests that go beyond those of the parties already before the court. We submit there would be little point in permitting an amicus to take a position distinct from the parties before the court if the court itself was then hamstrung to only consider the relief in the terms prayed for by the parties. And in terms of precedent, we submit that an amicus in appropriate circumstances may broaden the issues raised by the parties in constitutional litigation. We submit that that is not unprecedented. In Grootboom, for example, the main parties, when it came to the Constitutional Court, relied on Section 28 of the Constitution and the right of every child to shelter. And that was consistent with the position that the High Court had taken. In the Constitutional Court, however, the amicus introduced a challenge on the basis of the state's obligations under Section 26 of the Constitution. And this court then considered that additional ground as introduced by the amicus in that court and went on to grant the relief based on that further ground. Further, this court's wide powers to grant just and equitable relief has been canvassed in the applicants' heads of argument. And I note that they didn't get that far in the submissions, but I submit that the powers granted in Section 38 and Section 172 of the Constitution, the principles espoused in the applicants' heads of argument apply equally to the WLC's praise for additional relief, because this court's powers to grant just and equitable relief are very wide. In the circumstances and for the reasons which I will discuss shortly, the WLC asks this court to direct the respondents, when revising the THRR, to take into consideration the specific resources required to police gendered crimes, such as sexual offenses, domestic violence, intimate partner violence, and femicide. And to the extent that this court is of a mind to appoint a panel of experts as suggested by the applicants to monitor the respondents' compliance with its orders, the WLC would further propose that the panel should include at least one individual who has expertise in the area of violence against women. I turn then to deal with the WLC's application for leave to admit additional evidence. The additional evidence is largely contained in paragraphs 41, 49, 105 to 132 of the WLC's answering affidavit. And it contains recent statistics and reports relating to violence against women and emphasizes the state's own commitment to address the prevalence thereof. And again, because the WLC was initially joined as an amicus in the Equality Court, and its position in this court is not dissimilar from that it played in the Equality Court, the WLC's application to adduce further evidence we submit should be considered in light of the rules that apply to amici in those circumstances. And this court recognized in Children's Institute versus Children's Court of Krugersdorp that amici play an important role, first by ensuring that courts consider a wide range of options and are well informed, and second by increasing access to the courts by creating space for interested non-parties to provide input on important public interest matters, particularly those relating to constitutional issues. The judgment also stressed that allowing an amicus to adduce evidence in public interest matters best promotes the spirit, purport, and objects of the Bill of Rights, and that the correct interpretation of Rule 16a must be one that allows courts to consider evidence from amici where to do so would promote the interests of justice. Justice
At that point, Ms. Christians, my colleagues may put questions to you now.
Thank you, Justice Madlanga. There isn't anything at this stage. I'll continue.
Ms. Christians, could I ask? I think the statistical information with regard to gendered crimes probably is not in dispute at all, and the need at some level to address that probably can't be disputed. However, the Equality Court was quite clear in dealing with the grounds of discrimination that it found to have existed. And in paragraph 92 of its judgment, it dealt specifically in thanking the amici that the discrimination that was challenged in the proceedings before it was challenged on the basis of race and poverty and not gender. And that would explain why the order that it finally made was confined to, and one must accept the intersectionality argument. But is there not a risk that if the court, provided that it was minded to consider the grant of relief, would through the back door, as it were, make a finding that indeed the THRR discriminates on the basis of gender? It may well do so, but that wasn't before the court. So is there not that risk, notwithstanding the role amicus played and the ability of amici to broaden the issues before the court? But given what is before us now, the order of the Equality Court has not been appealed against, and that's the order that this court must work with if this court is minded to. How do you suggest we overcome that if it's capable of being overcome?
Justice Kalapan, thank you for that question. The first is we accept, of course, that that finding by the Equality Court has not been appealed against, and the procedural difficulty from the WLC at that stage was because it was an amicus in the proceedings. It did not have a right to appeal the findings of that court. And so it would have been constrained to take whatever, assuming that the issue of remedy was dealt with in the Equality Court, it would have been constrained to take whatever creative steps it was minded to do to reopen the door, as it were. But now we are before this court. And this court, at the very least, can comment on whether or not the Equality Court was correct not to consider an intersectional approach to the issue of discrimination on the basis of poverty and race, and to what extent that necessarily includes discrimination against or on the basis of gender. And so, as I've referred to the case of Grootboom, there the High Court, as I understand the judgment, expressly did not find that the discrimination or that the violation of the Bill of Rights was in terms of Section 26 of the Constitution. The High Court found that it was on the basis of Section 28 of the Constitution. That finding, as I understand, was not taken on appeal. Rather, the parties in the Constitutional Court proceeded on the assumption that the High Court was correct and focused their challenge on Section 28. The amicus in those proceedings then raised the additional challenge, or rather revived that challenge, on the basis of Section 26. And this court, notwithstanding that there wasn't an appeal against the High Court's finding, went on to find that the discrimination, or went on to find that the violation of the Bill of Rights was in terms of Section 26 and not Section 28, as the High Court had found. And so my submission to your question, Justice Kalapin, is that if this court agrees with the WLC that the allocation of police resources cannot be meaningfully revised without considering the intersectional perspective of discrimination on the basis of race, poverty, and gender, then this court can deviate, as it were, from the finding of the Equality Court in that regard. And then, even aside from the fact that,
and if it does so, must it revisit the finding of the Equality Court on the merits in order to lay a basis for the extended relief you seek, or can it simply deviate, as you suggest in your papers, on the basis of the relief only? Could there not be a disjunction?
Justice Kalapin, perhaps the simplest way to deal with that conundrum is, again, the difference between Grootboom is the very relief that was before the High Court was before the Constitutional Court, whereas here we've got a disjunct where the merits were decided and now it's only the issue of remedy. And so I'd submit that a practical way to deal with that conundrum is to view the merits judgment not as a judgment that stands on appeal to this court, but as an independent judgment that stands and holds precedential value. And so this court, when it considers the grounds raised by the WLC, can look at that judgment as if it would any other judgment when it considers an application before it and say that judgment was wrong and we're not going to follow it. And so if that approach was taken, there's still two options available to this court. It's to either grant the remedy as sought by the applicants, supplemented as sought by the WLC, or it could refer, if it is minded to refer the matter back to the Equality Court, it thereby opens the door to the Equality Court to reopen the issue of gender discrimination when it considers remedy, because this court will have said that to the extent that it ignored gender discrimination in the merits judgment, it was wrong. I hope that's answered your question, Justice Kalapin.
It doesn't necessarily answer it, it responds to my question, but thank you. And I think what the difficulty is that the main parties to the litigation don't come before this court suggesting that the Equality Court's judgment is wrong. They seek leave to appeal, the applicants seek leave to appeal on the basis of a constructive refusal of remedy. And they accept the correctness of the merits judgment. So I think that notwithstanding the valuable role of the amici, what you're suggesting may well extend beyond what is traditionally expected of amici. But thank you. And
if I might just respond to that briefly, is to highlight that in these proceedings, the WLC has filed a notice of application expressly seeking a leave to adduce further evidence and then also to extend the relief. So to that extent, I would submit that cures the problem of the parties not seeking the relief that we are proposing for. Moving then on with my address. In Koyabi, this court recognized that amici play a critical role in dealing with constitutional issues, highlighting that most, if not all, constitutional matters invariably have an impact beyond the parties before the court. And it went on to say that constitutional litigation by its very nature requires the determination of issues squarely in the public interest. And insofar as amici introduce additional, new and relevant perspectives, leading to more nuanced judicial decisions, their participation in litigation is to be welcomed and encouraged. And so we submit that the considerations apply in the present matter, and that the amplification of the evidence that served before the Equality Court should be admitted for the following reasons. The evidence sought to be admitted is materially relevant to the matter because it highlights the extent of violence against women in this country and why the respondents have a duty to take steps to remedy the problem. The constitutional issues raised in this matter have an impact beyond the parties directly litigating before the court, and they particularly affect vulnerable groups, including women. We therefore respectfully submit that this court would be slow to refuse to receive evidence that may assist it at arriving at a just outcome.
Excuse me, Ms. Christian.
Yes, Justice Matopo.
You are here riding on the backs of the applicants, am I correct? And,
That is, I will concede that, Justice Matopo.
and if the applicants do not come home on the arguments on constructive refusal, then you cannot get into their bus. Am I correct also?
Justice Matopo, I would qualify that by, again, highlighting, as I did to Justice Kalapan, that although the WLC wouldn't be before this court without the application initiated by the applicant, once it was joined to these proceedings, it did file a notice of application seeking additional relief. And so my submission is that whichever way this court is inclined to go in regards to the applicant's relief, the door is open for this court to deal with the relief sought by the WLC. And
Can I just ask, sorry to interrupt, just want to satisfy myself. Is it possible or practicable for, I put it no higher than that, for the applicants to fail and the amicus to succeed?
It's not possible in the sense of Thrr 2 of the WLC's notice of application. So to the extent that if this court refuses to get into the remedy that the applicant seeks, this court won't get to whether or not it should add a fifth consideration about police resources taking into account gender-based violence or violence against women. But having said that, if this court is minded to direct that the matter be referred back to the Equality Court, in doing so, this court can exercise its wide powers to make a declaration to the extent that the Equality Court was wrong insofar as it held itself to be constrained to deal with the challenges that were squarely raised before it by the applicant. In other words, to the extent that the Equality Court found that it couldn't make an order on gender discrimination because the applicant hadn't raised it, this court can say that the Equality Court was wrong. And the reason for that is over and above the additional evidence that's sought to be adduced by the Women's Legal Center, the judgment of the Equality Court didn't take into account the intersectional approach to discrimination as I submit it should have. And if this court considers the submissions of the Women's Legal Center and agrees with them that an intersectional approach to discrimination is necessary, this court can comment on it in its judgment. And in that way, if the matter does go back to the Equality Court, the two judges who ultimately hear the issue of remedy won't be bound by the Equality Court's judgment on the merits, because it will have the benefit of this court's commentary that the merits judgment to that limited extent was wrong.
Please continue with questions.
Thank you, Justice Madlanga. Thank you, Justice Matopo. So having dealt with why the additional evidence must be adduced or why we submit it must be adduced, I'll deal with very briefly with the actual content of the additional evidence sought to be admitted. As stated, the WLC's affidavit in this court discusses the statistics of violence against women up until 2020. And these include 2019-2020 Victims of Crime Survey, which revealed that there were no significant changes in the prevalence of sexual offenses over the period 2015 to 2020. And the survey also cautions that only 6 out of 10 households that experienced sexual offenses reported them to the police, highlighting the problem with underreporting. And then for the period 2019 and 2020, the number of victims of sexual offenses increased by almost 20%. And while the sample size was too small for disaggregate estimates to be calculated, I submit we can safely assume that the vast majority of victims would have been female and or children. Then on the 11th of March 2020, and this is really the important part of the evidence that the WLC seeks to admit, is the Department of Justice published the National Strategic Plan on Gender-Based Violence and Femicide. This strategic plan not only shows a clear acknowledgement by the state that violence against women has reached intolerable proportions in our country, but that there is an unequivocal and unavoidable obligation on the state, including SAPS, to take steps to combat the problem. The purpose of the strategic plan is to provide for a multi-sectoral, coherent strategy and programming framework to ensure a coordinated national response to the crisis of gender-based violence and femicide by the government of South Africa. The strategic plan specifically anticipates that government departments will align related outputs within a 5-year period. And I think we're already 2 years into that period. This objective has direct implications for SAPS's allocation of resources to effectively police gender-based crimes and the manner and method by which they do so. Some significant findings emerge from the strategic plan, and that is numerous prevalence studies since 1998 from different settings and populations confirm that gender-based violence is highly prevalent and endemic in South Africa, with physical violence being the most common form of gender-based violence reported. More than 1 in 3 women have experienced physical and or sexual violence at the hands of an intimate partner. Due to underreporting, the true number of sexual offenses is significantly higher than what is reported to the police. Shockingly, only 8.6% of reported crimes result in a conviction. The strategic plan also highlights the true impact of violence against women extends to compromising women's sexual health and reproductive health, their mental health, social well-being, productivity, mobility, and capacity of survivors to live healthy and fulfilling lives. Violence against women is therefore a barrier to the achievement of substantive equality for women as envisaged by our Constitution. The state, through this strategic plan, has acknowledged that the social context of violence against women is rooted in historical apartheid policies, and that poverty and gender-based violence are mutually reinforcing, with poverty increasing women's risk of experiencing violence, and that such violence increases the risk for poverty. This is an implicit acknowledgement in the strategic plan of the intersectional discrimination that this court is asked to deal with. And we submit it is therefore inherently irrational for the state not to prioritize the allocation of police resources to address this cruel legacy of apartheid. The irrationality is amplified all the more by the strategic plan, which highlights on the one hand, the various legal frameworks that have been put in place to promote and enforce gender equality, but juxtaposes on the other hand, the lack of effective implementation of those laws. And SAPS, as a signatory to the strategic plan, has committed to numerous performance areas and activities. And despite those commitments, there is not one reference in the THRR to tackling gender-based violence and violence against women.
Ms. Christian, excuse me again.
Yes, Justice Matopo.
I just want to find out from you whether these submissions that you are making before us, laudable as they are, if the applicants don't come home at all before us, would you be able to make these submissions when a remedy is being discussed or determined before the Equality Court? I'm saying this, if there is no declaration from us or no order saying go back to the Equality Court and determine remedy. If, for example, the approach we adopt is that you have not made out the case for this court to have jurisdiction. In other words, you failed to advance a case based on constructive refusal. and the application is dismissed. I'm just thinking aloud. The applicant will go back before the Equality Court because one would regard the matter as unterminated or still pending. What I want to know from you is whether you would still be able, before that Equality Court, to make the submissions that you're making before us, or your door would be shut.
Justice Matopo, the risk is that certainly the WLC can do what it did in this court and apply for leave to adduce further evidence, as it has done in this court, and it can apply to extend the relief sought as it does in this court. The difficulty which the Equality Court would face, which this court, I submit, doesn't, is that presumably it would go back.
Excuse me, where would you want to extend the relief? Before us or?
So in the applicant's notice of motion, they seek in paragraphs 2.1.1 to 2.2.4 the factors that must be taken into account when the THRR is revised. And what the WLC proposes is a fifth consideration, being whether sufficient weight is given to the proliferation of violent crimes against women in the allocation of police resources. So that's the extent to which the WLC in this court has sought to extend the relief sought by the applicant.
But what I want to ascertain is, would you still be able to make the very same submissions before the Equality Court when remedy is being determined?
Justice Matopo, the WLC would be able to make those submissions and make the application. The difficulty or the risk that it faces is that the two judges hearing the remedy will consider itself bound by the two judges who considered the merits and would only, in principle, deviate from the merits judgment if it found that it was clearly wrong or on some other basis. Whereas this court, sitting as an appeal court.
No, but look at it this way. That's not how courts operate. Justice Bokwana is now elevated to the SCA. Now, if remedy is determined, either she agrees to come back and deal with the issue of remedy, or JP Hlophe decides to allocate the new judge, subject to the parties agreeing, obviously, to join in with Justice Dolamo to hear the remedy issue. And there is no possibility that the remedy judges would upset the merits judges. And assuming it's a new bench, and it will be something that is completely unprecedented, you can't set aside that order. So they sort of bound by the order of Dolamo and Justice Bokwana Mabinda. So yes, Justice Matopo. My concern is the arguments that you're raising, which appear to me to be sound and attractive, whether you would still be able to do that in the light of the court order, I think paragraph 1 and paragraph 2, whether the door is not shut in your face to be able to make the submission. But if you say to me that during the remedy, you would still request that you be heard and it is competent that you can file whatever submission to the court, it's something that I'm mulling over now.
Yes, Justice.
And I have a court order here, and I'm just wondering whether they may not shut the door to say, you're not competent to come before us, and you are now before us, and whether whatever we do would not be perceived as a grave injustice to the fifth respondent. Please help me to settle down on that issue.
You explained
before you respond, your 30 minutes is up. In fact, it's 33 now. So how much more time do you want?
Justice Madlanga, if I can respond just finally to Justice Matopo's question, and then if I can have just 3 or 5 minutes to make one point.
Or after those.
After.
All right. Thank you.
Thank you, Justice Madlanga. So as I said, I think Justice Matopo, you explained what I was trying to explain a lot better than I did. And while I say that the WLC can be creative in the sense that it can go to the Equality Court on the remedy issue and make these submissions, the two judges who hear the remedy will be bound by the merits judgment in a way that I submit this court isn't. And so there, although we can try and make these submissions, the risk is that those two judges, considering themselves bound by the two judges who determine the merits, will not be inclined to grant the relief sought by the WLC. And so for that reason, I submit that it would be in the interest of justice that even if it is just this issue on reopening the gender-based discrimination when it comes to police resource allocation, that it is in the interest of justice for this court to determine that issue, even if it then refers the determination of the remedy back to the Equality Court.
I'm not altogether sure that that's correct, Ms. Christians, but you of course, I'm engaging you so that you may respond. And maybe you are not even done, my brother Justice Matopo, but I just wanted to zoom in on this point. My understanding of how intersectionality works is that the main issue raised or the main ground of attack may be A. But whilst you are focusing on A, you are able to say because of intersectionality, something else is also impacted. So you may not necessarily have to even amend or add to, or supplement and so on. You still rely on A, but you say because of intersectionality, B is also impacted on. But to the extent that there may not be evidence that shows that B is also impacted on the basis of intersectionality. So it's on that basis that you may want to lead evidence showing that indeed B is impacted on. So the short point I'm getting to is, if I'm correct on that approach, the door would not be shut to you or would not be shut in your face on that basis, if I'm correct. So you may have to answer the question, am I correct?
Yes, Justice Madlanga.
Is that how intersectionality applies or not?
Certainly, Justice Madlanga, and for what it's worth, I agree entirely with you on that point. And should it get to that, that is precisely the argument, or one of the arguments that will be led in the Equality Court. The concern that we have is that if the Equality Court deciding remedy doesn't have the benefit of a pronouncement by this court, it will take the same approach that the Equality Court dealing with merits did and say the challenge before us is on race and poverty, and we're not dealing with gender-based violence. And if that's the case,
then you may have
to
argue your lungs out to convince that court on how exactly intersectionality applies.
Unfortunately, I wasn't involved in the Equality Court proceedings, so I don't know to what extent this line was argued. But the risk that I want to highlight is that without a pronouncement on this court clarifying that the court hearing remedy can revisit this issue based on an intersectional approach, then we might end up in the same position and having to, the WLC or some other public interest organization having to challenge the THRR in new proceedings and start the whole process afresh. So in the interest of justice, and I hate to say expediency, I would urge this court to at least make a pronouncement that to the extent that the Equality Court didn't approach the matter from an intersectional perspective, it was wrong to do so, and that the court hearing remedy is entitled to relook at the intersectional discrimination on the basis of race, poverty, and gender.
My apologies, my brother Justice Matopo.
And then, since I have run out of time, I would like to conclude by referring to the very essence of intersectionality and why it is so important, particularly in this case. and why it would not be in the interest of justice not to deal with it squarely. And I can say it no better than Justice Kampepe did in Chabalala, where she stated powerfully and unequivocally, rape is a scourge that affects women of all races, classes, and sexual orientations. But we know that in South Africa, rape has a pernicious effect on Black women specifically. And to erase the intersection is a rhetorical gesture that not only negates the lived experience of women at these intersections of oppressed identities, but also means that our response to the crisis will always be deficient and under-inclusive. Speaking of rape on these terms is not a preoccupation with personal identity, but an analysis of the ways in which power impacts particularly women. And thus, in the context of intersectional discrimination, a revision of police resource allocation which seeks to address discrimination based only on poverty and race will undermine the pursuit of substantive equality if it ignores gender as an additional ground of discrimination. And so, to use the words of Justice Kampepe, it will mean that our response to the crisis of violence against women will always be deficient and under-inclusive. And those are my submissions, Justice Madlanga.
Thank you very, very much, Ms. Christians. Ms. Williams?
With my video, yeah. Thank you, Justice Malanga. At the commencement or at the meeting earlier this morning, I had indicated that I would be using the 10 minutes. I think it's been considerably shortened. And if I could just start off with the Women's Legal Center, just a couple of aspects that I'd like to highlight about them. Firstly, they participated in the Equality Court proceedings as an amicus. We consented to their admission. In the Constitutional Court, they're participating as the fifth respondent. I'm not sure how this came about, and in the course of why they were cited as a fifth respondent, and in the course of my learned friend's argument, Ms. Christian's argument, she seemed to vacillate between whether they were a party or whether they were an amicus. That's the first difficulty with their standing in this court. Then I'd just like to deal very briefly with the judgment. They directly raised in the Equality Court the intersecting forms of disadvantage suffered by women and girls in South Africa. We see that from paragraph 92 of the court's judgment. The argument was that the SAPS's commitment to providing resources to address the high levels of violence against women has not been met. They highlighted the inadequacies of SAPS's effort to combat gender-based violence. So all of this was in the court of first instance. But the court concluded in paragraph 92 that this was a challenge based on race and poverty, not gender. Now, this has not been addressed directly by my learned friend, other than the fact that it may be, as explained by Justice Madlanga, that you look at A and B then arises, an intersectional submission. So it's against that background that I think that we just need to put the WLC into context. The point has been made, a very sweeping allegation, that there's not one reference in the revised THRR to gender-based violence. Well, this is manifestly not so. At page 651, paragraph 9 of the revised documents, the SAPS discusses the weight contributing factors of reported crime when determining resources. They pertinently refer to gender-based violence and murder cases having influenced the contact crime weight. So for operational posts, the weight enhanced with regard to previously 1 post for every 20 reported cases has now enhanced to 1 post for every 10. So you see a doubling up, and it's in the context of gender-based violence and murder. So it's incorrect to say that the THRR says nothing in that regard. I also think it's important that there's clarity on the status of the 5th respondent and or the amicus, because important considerations follow. As a 5th respondent, we have no right of reply to another respondent. This is why I elected to take the address time this morning, because how else would I respond to them? Secondly, if they are an amicus, as Ms. Christians appeared to accept during the course of her address, they have the same constraints that this court recently outlined in the Secretary Judicial Commission v. Zuma matter, which is already before the court in the bundle, in particular 74. And if I could get to Judge Matopa's question, the question was, if the applicants fail, can you succeed? And I thought I heard some prevarication on the answer. And I'd just like to clarify it. If the applicants fail, the amicus cannot succeed because there's nothing that they're going to participate in before this court, exactly as this court decreed in 74 of the Judicial Commission judgment. The role of the amicus is also restated in paragraph 76 of this judgment, and the amicus in this matter is diverging from that. They're seeking to put new evidence before the court, wrongly so, without showing the relevance. And while I accept what Justice Collipin said about these statistics, there's still a duty upon them to show and to satisfy this court why they wanted to place it before the court. Now, the SAPS here recognizes that there's an issue with gender-based violence, hence the introduction in the latest iteration of the THRR. So we're saying that if the applicants fail, the 5th respondent or the amicus, the WLC, must fail. They've also not described what it is in all these internet links that they want to put before the court. This court is well versed with the likes of cases such as Swiss Borough. You can't just refer to a document without telling the court what you want to refer to and what the relevance is. A further problem relates to the requirements with Rule 31. We submit that they haven't complied with it because it's a stringent test for admission, and this is not how you go about satisfying a court that the evidence is irrefutable. Where's the evidence that this survey was done in such a manner by these people on this date, and for these reasons, its validity is acceptable and cannot be contradicted? So for all of those reasons, I would submit that whatever the 5th respondent wishes to do, or the 5th respondent wishes to place before the court, should simply be refused. It has no place in this court. Then I think I used 3 of my 4 minutes so far. If I could just move on to some of the submissions made by my learned friend, and in particular, if I could just address some of the questions raised by Justice Shiki. I think a good starting point is the chronology which the SAPS prepared and which the court finds at 660. It starts at 665. It's Annexure AA5 to our papers. And one of the questions that Mr. Hawthorne was asked about on this issue of constructive refusal related to what happened before the court, the Equality Court. And the first request that we see for a date is actually identified on page 667, and the letter is dated 18 September 2019. That letter is at page 269 of the record, and the letter concludes in paragraph 5 on page 270 to say, the applicants and their legal team are available for the following dates. Any dates of the week of 9 December 2019 are interposed to mention the recess time, or 2 to 3 March, 16 March, or any date in April. Alternatively, any dates in the second term of 2020. So firstly, this request for dates, there's no urgency in that regard. And the applicants already in September of 2019 appear to have no difficulty waiting for a date to be allocated some 9 months hence in the second term of 2020. We then have the letters which were given or addressed to Justices Delamo, and initially 2 to Justices Delamo and 1 to Justice Schlopper, the Judge President Schlopper. And I again want to emphasize that in those letters, there does not appear to have been any haste on the part of the applicant to have the matter heard. In fact, they asked in the letters, which it's annexes 27, 28, and 29 to the finding papers. They asked in these letters for an allocation in the second, I think the first and second term, if I can just take the court to the correct pages. 27 is the letter of 11 February 2020. It's a request for the hearing in the first or second term of 2021. The second letter repeats this request on the 1st of March. And then the third letter addressed to the Judge President again repeats this request. So by the time the letter of 19 March 2021, which I might add, put the Judge President to terms that if there's no response by a fixed date, I think it was 2 weeks later or 2 weeks later, 9 April.
The 10 minutes is up, Ms. Williams.
Fine, my lord, that's
you may continue.
Thank you. Just if I could just finish this point. They asked for a date in the first or second term.
You may argue to the end. Just continue until a colleague asks you a question.
Thank you, Melissa. And thank you, Justice. Even before the start of the second term, they instituted the Constitutional Court application. Now, the problem with that is they instituted it before their self-imposed or the date requested by them had even passed. In fact, the second term hadn't even begun by the time this application was launched. Now, my learned friend, Mr. Hawthorne, makes
Sorry, Ms. Williams, could I step in there and indicate that while that may be so, on the facts before us, that there hadn't been a response to the matter being enrolled on the time that they'd indicated. But more important than that, given the serious and far-reaching findings of the Equality Court, that an important organ of state has been discriminating against poor and Black people for in excess of 20 years, in a constitutional democracy committed to dealing with the injustices of the past and to advancing substantive equality, would that not in itself, notwithstanding what the applicants may or may not have said, prompted everybody, the parties, the court as well, to deal with the matter with the requisite degree of urgency? And it's not as if it was simply the responsibility of the applicants to do so. I would say that in order to bring the unacceptable practice in line with the Constitution, it was a joint responsibility shared by everybody. And therefore, the timeline must be viewed in that context, not so.
Justice Collipin, I agree with you that everyone had a responsibility in this regard. Certainly, from the SAPS's perspective, there were these initiatives taken to implement the Cartlisha Commission's findings, to start the revision of the THRR almost immediately after it was decreed by the court that they need to review it. That's dealt with in the affidavit of Brunt and it's footnoted in our heads of argument. But the simple point that I make is they asked Justice Delamo for a date in the first or second term. There would have been nothing stopping Judge Delamo to respond on the 11th of April to say, you can come to court next week. And that's the objection to what they did in this matter. A further objection relates to the letter that we addressed to them. Again, the olive branch is extended and we tell them, let's make a joint approach to the judge president. That is Annexure AA3 to our papers on page 659. Let's make a joint approach to the judge president that the matter be allocated. There was some toing and froing. The applicants did not want Judge Delamo to hear the matter. We said we didn't have a problem, but we'd abide by whatever was said in that regard. So this letter was rejected out of hand for reasons which I might add are nebulous to say the least. In fact, it was rejected on the same day at page 663, where they say, on the 12th of April, we issued court papers in the Constitutional Court due to the failure of the Equality Court to finalize the matter. What they don't say and don't engage with and don't address is why they themselves requested a hearing in the second term and why they did not wait that period before coming to this court on the basis of a constructive refusal. How can there be a constructive refusal if the date by which something had to happen had not passed? And that's the flaw in their argument. We've also addressed in our heads of argument, and it's not necessary to go through it, why we say there's no constructive refusal. Then,
Ms. Williams, on the point that you've just made about the offer of the respondent of a joint approach to the judge president, in the absence of any response to the applicant's letters, at least 3, I think, why would a joint approach have produced a different outcome?
Because when parties need dates, you go and see the judge president in this division, and he would allocate a date. There was an additional reason that the judge president had to be seen in this matter, and that's because Judge Bukwana was no longer here. In fact, there was a third reason that the judge president had to be seen in the matter. My learned friends for the applicants did not want Judge Delamo to hear this matter. So a new bench would have had to have been appointed, and only the judge president could do so.
And is that set out in the letter, in the offer that the respondents made to the applicants?
Our letter.
Let me just finish, please, Ms. Williams. That it was necessary to approach the judge president in order to obtain dates, and that it would be necessary to approach the judge president in order to allocate a judge to hear the matter.
Yes, it says in paragraph 2 on page 660. This is now after we've received the application, Justice Thrr, that on having considered the application, our lead counsel approached your lead counsel with a proposal on 26 April 2021 that the parties seek an urgent audience with the judge president on a joint basis, requesting that the matter be allocated. And then further down, the applicants, given the complaint lodged with the JSC against Delamo J, the applicants request that any directions issued to the Equality Court make provision for the determination of the outstanding issue by a panel of 2 judges that does not include Judge Delamo. Our response to that is, our client's response to that was that he did not consider it appropriate to direct to the judge president who the matter should not be allocated to. But that did not preclude the applicants from addressing the judge president on the issue, and the SAPs would abide the outcome. So there were a number of reasons that this invitation should have been taken up if the applicants were serious about pursuing the relief in the Equality Court. Instead, it's rejected out of hand. We also say in paragraph 4 of the things as indicated by our lead counsel, we are of the view that such a request should be made on an urgent basis. We are of the view that any application to the Constitutional Court to rule on this issue should not be pursued until the judge president has been approached. The response was an outright refusal to even see the judge president. So it's against that backdrop that constructive refusal needs to be examined. I've said you cannot have a constructive refusal if the date by which a hearing was requested had not even passed.
Ms. Williams, does the respondent accept that there can, in appropriate circumstances, be a finding of constructive refusal?
Yes, the respondent would have to accept that in light of the finding in New Clicks. The problem is that the facts of New Clicks differ toto kylo from the facts of this matter for the reasons advanced in our heads of argument. And as
let's just leave New Clicks out for just a moment. So the respondent accepts that there can, in certain and appropriate cases, be a finding of constructive refusal to hear a matter, in this case, constructive refusal to grant a remedy. So it would then follow that there has to come a time where the delay is sufficiently unreasonable to make such a finding. Of course, the delay and the circumstances surrounding the delay.
I'm not aware of delays equating to a constructive refusal.
Yes, obviously delays together with all other factors, Ms. Williams, relevant factors, such as the nature of the matter, the impact of the refusal to grant a remedy. If one accepts that there can be a finding of constructive refusal, it would then follow that there must come a time or a point in time where such determination is made based on the circumstances and relevant factors in the matter?
It's a matter which would need to be determined on a case-by-case basis, firstly. Secondly, here we have a delay of between,
Let's deal with the principle, Ms. Williams, before we get to the facts.
All right. I'm not sure that a principle has been established that I'm aware for a constructive refusal to grant a remedy.
Okay, let's go back to my first question, where you said you accept that in appropriate circumstances, such a remedy can be granted.
Yeah.
In your submission to this court and to assist this court, when could or would such a remedy be permissible?
In the circumstances such
Williams, as you answer that question, could I just add an element to that which may make your answer complete and respond to a theme on relating to that question? The whole discussion around constructive refusal is located in Section 34 of the Bill of Rights. And Section 34 provides a right of access to have a justiciable dispute decided. And I emphasize the word decided. And if there's a right, there must be a corresponding obligation. And so the obligation to decide the dispute would be on a court, on an impartial forum that the section contemplates. Section 8 in turn provides that the Bill of Rights binds the judiciary as well. So arising out of that, and going back to the question of my sister, Justice Thrr, when would circumstances arise that would constitute a constructive dismissal? What do you say about the submission that Section 34 creates a constitutional obligation on the part of the court to deal with the right, a corresponding constitutional obligation, and Section 237 in turn provides that all constitutional obligations must be discharged diligently and without undue delay? Does that not complete the context within which the debate around a constructive refusal then is properly located within the Constitution? And does that not, as it were, heighten the constitutional imperatives?
Justice Sullivan, thank you for that. The sound has gone awry.
Colleagues and all participants, please check background noises. Please continue, Ms. Williams.
Thank you, Justice Mhlanga. Justice Kalipin and Justice Thrr, thank you for the questions. And if I can answer this as best possible under the circumstances, I accept what has been put to me about Section 34. Fact that this is binding on the judiciary. But it would be setting a very dangerous precedent in this court, because we will have applications like this for damages where it's taking too long. It raises the question, what happens to reserved judgments? If a judgment is reserved—
Ms. Renata, Ms. Williams, I apologize profusely for interrupting you, but we're not at the stage where we're dealing with the consequence of the granting of such a remedy. We may get there. We're dealing with when such a remedy should be granted, having regard to the rights in Section 34 as enunciated by Justice Kalipin.
All right. Okay, let me just respond to that firstly. I think that if the facts were placed before the court properly and which supported a finding of a constructive—
Can we deal with the test first before we deal with the facts? What we say is the test as to when a court has refused to grant a remedy, or when another court or a superior court can find that that matter remains incomplete.
The test would Mr. Hawthorne propagated a test of where an injustice would arise. That's his test, or the test submitted by him. In our instance, and I'm afraid I don't think we can argue a matter without the facts. In our instance, we have a situation where the SAPs accepted.
Do you agree with the tests proposed by Mr. Hawthorne?
I would imagine that that is an important consideration. I haven't had a chance to apply my mind to a test on, or what would be an appropriate test, but that would be one of the considerations that the court ought to take into account. Now, that comes back to the facts of this case. Where is the injustice? Judge Tron, you've disappeared. Are you with us?
Ms. Williams, I wonder if I could put it in a slightly different way, which may perhaps advance the debate. Your attention has been drawn to Section 34. Does an appellate court have the competence to enforce the obligations of a lower court to determine a matter?
No. That's Section 173, where in our heads, 173. Well, firstly, we were not able to find.
Why not?
Because 173 refers to the court's inherent jurisdiction to regulate its own procedure, not the procedure of another court.
But Ms. Williams, if there is an infringement of a constitutional right of access to a court, and in order to give effect to that right, the obligation must be discharged by a court, are you saying that that's a right that is simply incapable of enforcement?
Well, we deal with this in paragraph 67, in paragraph 67 of our heads of argument, and the court's powers in 73 does not extend to regulating procedures in other courts. 171 of the Constitution says all courts function in terms of national legislation, and their rules and procedures must be provided for in terms of national legislation. We don't know.
What about, I'm sorry to interrupt, but I think we all understand the content of that section. What about Section 38?
Section 38 may afford, where the court is enjoined or empowered to grant appropriate relief. So Section 38 on the would address that, but there's an antecedent question, Justice Unterhalter. Have they made out a case for direct access?
No, I understand you're very keen to proceed to the facts, but it's important also that we understand what our competences are.
Correct. So yes.
Assuming it is competent for this court to enforce Section 34 rights as against a lower court, why would this court not simply make an order requiring the Equality Court to constitute itself to hear the remedy, rather than treat constructive refusal as the basis for enforcing a Section 34 right?
Well, because the applicants have not established a constructive refusal here. I've passed that. And to remedy a wrong, such as an infringement of a Section 34 wrong, the court would be empowered to issue a directive of that nature.
I see. So, and would you accept that that would be the lesser, it would be a less intrusive remedy than simply treating the outcome as one of constructive refusal and having to engage this effectively as a court of first instance?
infinitely less intrusive, infinitely less sorry, the word just escapes
Thank you.
me.
I think I have your.
I think yes. All right. So yes, if the court at the level of principle to vindicate rights, I think the court would be empowered to issue a direction on these facts should the court exercise that power. We're dealing with a delay of a few weeks. A request put by my learned friend for a hearing by a particular date, where there were still months to run before that date was reached. Does this make out a case for direct access? Is this the sort of matter where this court should prescribe to the Equality Court how they must run their court?
Miss Williams, let me posit this scenario. You have an RAF matter where merits and quantum are in dispute. The High Court judge gives a judgment on the merits and doesn't deal with the quantum issue. And he or she has been approached on several occasions to make a determination on the quantum, as in this case. And nothing comes out of it. An approach is made to the judge, concerned. Judge does not say a word on when the quantum issue is going to be determined. And a party becomes dissatisfied and approaches not the Supreme Court of Appeal, approaches this court and saying there has been a constructive refusal. Please entertain the matter. The order that would be sought from us, I just want to deal with the difficulties of the order. If a party says to us, the experts' reports and everything else has been filed for the purpose of a determination of quantum, you can make, as the Concord, you can make that determination. Or if a party says to us, please direct the court, the Equality Court, to hear the quantum. I've posited two scenarios to you, and I just want to find out from you whether it is permissible for this court to do that.
It would be permissible for the court to hear a matter as a court of first and last instance, i.e. the quantum aspect, but that is a power which is sparingly exercised. We've given the court the authority in our heads of argument. The preferable manner to deal with it would be to refer it back to the court, because for the reasons disputed materials, disputed facts, evidence, and so on and so forth. Again, one cannot divorce oneself from the facts of a case. And in this matter, unfortunately, we have much toing and froing about what is required here. There was a submission made in my learned friend's heads of argument. I think it was paragraph 6 of the heads of argument. Sorry, that's where they dealt with the mootness, which had been raised earlier with paragraph 2. But there was a suggestion made in their documents that all the evidence that was required for this court, the Constitutional Court, to make a decision was already before the court. Well, that is manifestly not so. Firstly, the THRR, which is before this court, is a draft. It had not been signed off. It was busy meandering its route among the various role players at the time when these papers were filed. So we don't know if the iteration before this court is the final iteration, firstly.
Ms. Williams, please hold your thoughts. It's not a technical issue. We are getting some feedback from you. Is there more than one device that's connected in the room where you are?
Yes.
If there is, can we switch it off? Because I think that is the cause of part of the interruptions that we've been having. Where there's more than one device connected, they seem to fight with each other.
They're definitely doing that, Justice Tron. We've switched off. All right. If I can just go back to the question which was put to me now, Judge Matopo. In this instance, we know that the THRR is in draft form, it's going its route, and then after that, there's going to be a public participation process. So the final iteration, we don't know. But I think it's important just to highlight what my learned friend, Mr. Hawthorne, said in paragraph 58 of his heads of argument. He says, it is also true that the current draft amendment may resolve some or all of the unfair discrimination identified by the Equality Court. Then he goes on to deal with the supervisory relief. I don't think it's necessary to address the court on that aspect because we have dealt with it in some detail in our papers.
Can I interrupt you? And I think this will be the last time.
It's
you were debating the question of the test or the principle with my colleagues, Justice Thrr and Justice Kolapin. Your colleague, Mr. Hawthorne, said in his submission that we have to rely on the judgment in Walhouse. And I identified 3 principles or 3 requirements. It has to be done in rare cases, 1. 2, there has to be a grave injustice. 3, there has to be a failure, maybe a failure of justice. Now, what I want to know, given the facts of this case, does the applicant come home on those 3 aspects, mindful of the fact that 1, we have Section 34 of the Constitution, your right to access. Does they come home? And if they don't, are we in the arena where Justice Majid said, what is being sought from us, it's an unprecedented order? Well, I just want you to...
Just in a nutshell, they haven't established the 3 criteria in Walhouse. And as Justice Majid correctly emphasized, this procedure is wholly unprecedented. I think, Justice Matopo, you've actually highlighted the risks attendant on this, because it's not just a question of a judge refusing to set a matter down on quantum in the RAF case that you've given. If that should happen, there's a judge president that oversees the functioning of a court. In fact, I've yet to hear of a matter which has just not been set down. The difficulty with our matter is the end of the 2nd term wasn't even nigh. It was weeks off, months off before they launched this application precipitously. So I'm not aware of a judge simply refusing to hear part 2 of a matter such as quantum or any other matter where something has been hived off. But if it has been hived off and you're not receiving a date, which I'm also not aware about, there are other remedies. The Con Court is not the port of last resort. And that is where this matter breaks down. They haven't established the irregularities that were present in Wallace. They haven't even shown a breach or an infringement of Section 34. So from our perspective, and while I think you could say that there are cases where a constructive refusal can occur, as happened in New Clicks, and as Judge Unterhalter pointed out, there was no effort here to develop that. They accept New Clicks and they try to rely on New Clicks with the constructive refusal. We say you can't for the reasons articulated in our heads. So what we are submitting is that this matter should simply be refused. The appeal should be refused as prayed at the conclusion of our heads of argument. If the court is not minded to refuse it out and out, then the only other order that should be made is perhaps a referral back to the Equality Court with a direction as to when it should be heard.
William, just on that. Sorry.
I'm not sure. Is it Judge Collipin? Hi, sorry.
You can go first.
You're muted, my brother. Justice
sorry. I wasn't sure if Justice Matopo was finished. Maybe I'll wait for you.
Okay. Ms. Williams, in terms of the timelines, you have said there were three, for lack of better word, let me say 3 impediments. That is one, the parties or the applicants rather did not want Judge Dolamo. 2, Justice Bokwana had left for the SCA. 3, there was no response from Justice Hlope, right? And so I just want to know, in terms of the timelines, was that all of that in April? When it was communicated to you?
Before your response, Ms. Williams, your 45 minutes is up. How much more time do you want?
I'm just responding to the questions which Judge Matopo has put to me.
Are you otherwise done with your submissions, except for colleagues may still raise
questions? We've said what we need to say, Judge Muganga. I don't want to repeat what is in our documents, but if I could just get back to Judge Matopo's question. The first letter went off in February, and then a second letter went off in March, and a third letter went off to the Judge President. But all of these letters asked for a set down in the first or the second term. And the point is that the second term hadn't even commenced by the time the applicants jumped the gun and brought this application. The SAPs, being reasonable, approached them and said, let's go and ask the Judge President for an urgent date. Let's go there urgently. But it was rejected. We're not prepared to get into a debate about a recusal of Justice Delamo. Whatever the applicants want to do in that regard, that is their prerogative. We will not stand in their way. But no, they chose. The irony of the situation is, had they simply accompanied us, the remedy probably would have been determined by now. That's the reality. And I have other concerns about this relief, in the sense that if it's going to happen in this manner, where a judge has still got a few weeks to respond and to give a date, what now if the court roll is full for 2 years? Do you then come to the Concourt because your your Section 34 rights are being denied? Why should you displace other people who are similarly placed waiting for the hearing date? What happens if a judgment is reserved for 6 months or 8 months or 10 months or a year? Is this a matter which should engage the Concord? And that's the dangers of opening up this sort of matter and granting relief. So, subject to Judge Colliton's question, I think those are my submissions, subject to any other questions.
Thank you, Ms. Williams. I think in responding to the three elements that may trigger, as it were, the intervention of this court, namely that it should be a rare case, that it should result in a grave injustice, and that there would be a failure of justice.
Yes.
Would you not say that it is indeed rare that a democratic government discriminates against poor and Black people, maybe not intentionally, maybe inadvertently, but nevertheless, that is unusual in any democratic society, and it must follow that discrimination against poor and Black people on the scale and level that was found to exist must result in a grave injustice, because simply people's ability to just do the ordinary things is impacted upon by the lack of effective policing resources, which is exacerbated when those resources are unfairly allocated on the basis of race and poverty. And then finally, if a finding has not been vindicated in the form of a suitable remedy 3 years after finding, then that may well be a basis to conclude that there was a failure of justice. But even if those three requirements are not met, with the requirement that at least there's been a violation of their right of access to court, not stand under these circumstances, that may warrant at some level, even if it's at the minimal level, at a response or an intervention from this court to ensure ultimately that justice ensues and the rights in Section 34 are seen to be real. And in doing so, the court may well be mindful of the carefully structured role of different courts. So the lesser of remedy, as was put to you by my other colleagues. Yeah. What do you say about that?
Justice Sullivan, I agree. There's no issue that the discrimination must be addressed. On the applicant's version, it is being addressed. In fact, on the applicant's version, it's being addressed to the extent that the amended THRR may resolve some or all of the unfair discrimination identified by the Equality Court. So this, of course, raises another issue. If it is addressed satisfactorily, there would be no need to go back for a remedy. But that, to get back to what I had submitted at the outset, have they made a case for any intervention by this court?
Ms. Williams, if I may, on the response you've just given, that the discrimination is addressed, which standard would be used to determine whether it has been properly addressed? Let me give an example of what I mean. Since we've been referring to RAF matters, where there's been a finding of liability and quantum is delayed unreasonably, would it be appropriate for the RAF to come to this court to say, don't worry about determining quantum, because we are addressing that. We're making regular payments to the applicant. And soon, the entire liability to the applicant will be discharged. Would that be sufficient?
No, that wouldn't be sufficient, because the RAF can't discharge its liability in the form of interim payments. We have the once and for all rule, and we've got interim payments in terms of 34A if there's a need.
So what makes this situation different for a respondent in the position of SAF to say, we actually don't need a court to determine the remedy. We are doing so.
No, my lady. Sorry, no, Justice Thrr. I'm not reading to you from a SAPS affidavit, SAPS's heads. I'm reading to you from the respondents, from the applicants' heads. They are saying that
Now,
the current
I don't want you to read to me from anywhere, Ms. Williams. I would like you just to answer the question that I posed, please.
No. The SAPS is happy to go back before the court. This is why we wrote to them on the 30th of April to say, let's make a joint approach urgently to set down remedy. That is the SAPS's perspective. Applicants' perspective is that these improvements in the THRR may resolve some or all of the unfair discrimination identified by the Equality Court, in which event it would be completely unnecessary to go back before them, because what's going to be remediated? So I don't know why this was not taken up in argument. You can't have it both ways. You can't say that these milestone improvements to the THRR may do away with or will address that discrimination, and then by the same token want to get the Concord to determine a matter.
Ms. Williams, is the answer to that not that what the applicant says is that for the first time, the THRR is meaningfully engaging with the findings of the Equality Court, and they regard that as something positive. However, from your side, that THRR is far from complete. To use your words, it's meandering somewhere through the system. When there's an urgent matter that requires to be addressed. So is there not merit in the argument that even though the THRR represents a positive beginning to meaningfully address the problem, there is the need to ensure that ultimately it does address the problem? Because ultimately that's what an Equality Court must do. It must craft a remedy that's responsive and effective to the mischief that it has identified.
That would be the role of the Equality Court. The applicants seem to think that all of the unfair discrimination previously identified may be addressed. But in the transcript, in the answering papers, we deal with the checks and balances that the SAPs have implemented as well. We've annexed a spreadsheet which shows how this draft or that iteration of the THRR, the second one, not the IRS, my lord, Ms. Justice Collipin, how that has translated into better policing. And we gave statistics relating to 3 police stations. These have never been queried or questioned or issue joined with them. So there are 2 processes that are running in parallel here. The SAPs, despite never being under a court order to do something, has gone to enormous lengths to address the findings of the Equality Court and indeed those of the Kite-Leisure Commission. No court order to do so. It's highly improbable and unlikely under these circumstances that we're going to be dealing with supervisory relief we're not dealing with the recalcitrant respondent here. We're dealing with a willing, able, and compliant respondent. Equality Court did not tell them, SAPs, please go and fix up this plan and do so within a year or 6 months. But that notwithstanding, the SAPs has been working at it for a few years. So it's against that backdrop that we would ask for the relief set forth in our heads of argument and in our application to be granted. However, and while I am alive to the difficulties and the Section 34 issues raised by Justice Tron and by Justice Collipin, there can be no difficulty with a referral back, although I'm not sure on what basis the court would be empowered to do so. The applicant has not put anything before the court that would suggest that it may do so. We've not been able to find anything, and I think the answer is, as Judge Unterhalter said, probably Section 38. Justice Unterhalter. Apologies. Justice Madlanga.
May I raise something just on remedy, please, Justice Madlanga? Very briefly, it concerns rebuttal. In your heads, right at the end, the last page of your heads at 142, you set out what you submit your worship page. And 142.4 says, ordering that the matter be remitted to the Equality Court for a determination of remedy. Surely, if we dismiss this application in its totality, just hypothetically, that is current question is the end of the matter, because the matter must then be dealt with in the Equality Court. There's no need for an order like that.
That would be the default position, Justice Majid. Thank you for pointing that out. We should have picked it up and highlighted that to the court.
Yeah, I just want to clarify. Thank you, Justice Madlanga.
Thank you, Justice Majid. Thank you, Ms. Williams.
Thank you, Justice Madlanga.
Mr. Hawthorne, your 15 minutes.
Thank you, Justice Madlanga. There are 4 issues that I'd like to touch on briefly, and I'll try and get through them within the 15-minute agreed with you. The first is with regard to the test for constructive refusal of a remedy, and the debate seemed to be focusing on the question of whether a grave injustice might result following from the Wahlhaus principles. And our submission is that although the attention of the court has been focused on the question of the timelines and whether the extent of the delay in the court, the Equality Court setting the matter down was so unreasonable as to constitute a constructive refusal. Our submission is that those timelines and delays cannot be viewed in isolation, and one has to take as a starting point the importance of the rights under consideration, and that is not in dispute before this court, that this is rights that are of fundamental importance to potentially millions of people, and it goes to the core of the concerns of the Equality Act. And secondly, the urgency of a remedy. And in my initial argument, I took the court through in taking the court through the timelines. I dealt with how the applicants repeatedly stressed the importance of getting a remedy determined as a matter of urgency. Secondly, with regard to the question of on what basis this court could exercise jurisdiction, there are 2 alternatives. The first would be in terms of its inherent powers in terms of Section 173 of the Constitution, and these are dealt with in the SABC case by Chief Justice Langer from paragraph 35 to 40. I'd like to draw the attention of the court to what is stated in paragraph 40, where Chief Justice Langer said, in the absence of a constitutional violation, it is generally undesirable for this court to instruct the Supreme Court of Appeal how to regulate the conduct of its proceedings. So it clearly has jurisdiction. It flows from that principle state there, that this court would have jurisdiction to instruct the Supreme Court of Appeal how to conduct itself if there had been a constitutional violation established. And our submission is that there's a violation of Section 34. particularly viewed in the context of Section 237 of the Constitution.
Excuse me, Mr. Houghton, were the facts, did the Supreme Court of Appeal do what the Equality Court did? Or you just raising it as a fact that in the absence of a constitutional violation, we have to look at that? What was said in paragraph 40 of the judgment?
Justice Matopa, I'm raising it as a principle, a matter of principle, that if a constitutional violation had been established, then this court would have had power to intervene.
Thank you.
It wasn't established on the facts of that case.
Okay, thanks.
The third issue I'd like to touch on is what was put by Justice Unterhalter in the course of the debate with Ms. Williams. And in respect of remedy, it was proposed, why not, if this court has jurisdiction, why not order the court of the Equality Court to deal with the matter? And in our submission, that with regard to procedural matters, it follows from the Mukadam case that the paramount consideration is what are the requirements of the interest of justice. And if one has regard to the question of whether this court should determine a remedy or whether it should be referred back to the Equality Court for a remedy to be determined, our submission is that the interests of justice weigh strongly in favor of this court dealing with the issue, that what has to be determined is a simple question of, are the declaratory orders that were issued in December 2018, do they constitute an effective remedy, or is supervisory relief required, as argued by the applicants? And for us to have to go back before the Equality Court and have another hearing with counsel involved from 3 different sides and extensive argument, where everything is before this court, it has been fully argued, and if the declaratory order is, if the declaratory orders are sufficient, then the interests of justice strongly weigh in favor of this court stating that and putting the litigation to bed. And if not—
Mr. Hawthorne, you're presenting this as if it's a simple binary choice, but it isn't necessarily so. The question is, what is the draft THRR proposing? Do we even have the up-to-date draft? How far does it need further amendment? What more should be done with or without it? That's why I've said your supervisory order is simply displacing the kind of substantive questions on remedy that ordinarily a court of first instance would determine.
Justice Unterhalter, we submit that the points that you raise all indicate very strongly why a supervisory order is necessary, that the declaratory relief that has been granted and which SAPS contends is sufficient, do not provide an effective remedy on the facts of this case, simply for the—
I'm sorry to interrupt, but for the sake of time, assuming that's correct for a moment, why is the only other order your supervisory order?
We don't say that, Justice Unterhalter. We say that we've proposed an order and we're not wedded to that order. But if this court can craft a more effective, or we've put forward what is in our understanding is the best means of dealing with the problem. If this court is in a position to craft a more appropriate remedy, then we would have no difficulty with it.
But it's not simply a matter of throwing it back to this court. It's a question of squaring up to some of the questions on remedy, such as what precisely is in the draft, how far does it go far enough, in what respects could it go further, and so on. Those are matters. How are we going to deal with that?
But Justice Unterhalter, these questions, it's the SAPS has had three opportunities to deal with these issues and place evidence before the court. It was in the IRS, which should have been set out its plan in the mid-2019. It could have dealt with those questions then. In General Mbeki's affidavit in August 2020, it could have dealt with those issues in that affidavit, and it chose not to. And it could have made clear exactly what the process is with regard to the revision of the THRR, when a decision is expected as to whether or not the draft will be accepted in its affidavit in May 2021. It did not do that. The fact that we are left in the dark in respect to these issues cannot be, it's not due to the default of the applicants. It's due to the fact that SAPS hasn't placed the evidence before either the Equality Court or this court, despite having at least three opportunities to do so. So,
Mr. Hawthorne, that darkness should not lead to further darkness, in that this court must navigate through what is certainly a contested plan. The THR is far from complete. And certainly as we sit here, we don't have the evidentiary material to make a proper determination whether the THR adequately responds to the findings of the Equality Court. And that being the case, surely that sort of puts paid to that argument. And tempting as the invitation may be, this court would accept that invitation at great risks to really doing an effective job on remedy.
Justice, we say that the decision on remedy actually cannot be held off indefinitely whilst the THRR revision process winds its way through the system. And I've made submissions already to the effect that it seems as though it's been stalled. And if it is so that before one can determine remedy, one has to wait until that process has advanced or has been finalized, then we could be waiting for another 3 or 4 or 5 years before we get to the point where we can argue remedy. And that's
well, is that not precisely why, if this court would be minded at all to intervene, that the Equality Court is the right place to determine that? Because if there's going to be an unreasonable delay in the finalization of the THR, that court may, upon consideration of proper evidence, be able to craft a remedy that deals precisely and exclusively with the relief that needs to be given in the light of the findings that it has made. And that would be that court's duty to consider the various options. Yeah.
We would say, our submission would be that is not the case, that we submitted it's clear that declaratory order is not sufficient to give effective relief to the applicants or to ensure that the discrimination identified in the Equality Court judgment is addressed. It's something more than that is needed. And that issue we submit can be determined on the evidence as it stands on the papers at the moment, that we can't be held to ransom by SAPS and its processes before the remedy issue is ripe for hearing. Otherwise, as I just mentioned, it could be another 5 years before SAPS is ready to deal with the question of remedy. The final issue that I'd like to touch on is the question of the applicant's appeal against paragraph 2 of the Equality Court order. And it was put in to the Women's Legal Center, Council for the Women's Legal Center, that the applicants had abandoned their appeal against paragraph 2. And our submission is not accurate, that when this application was launched in April 2021, there was a paragraphs, I think it was paragraphs 2 and 3 of that notice of motion challenged, sought leave to challenge paragraph 2 of the order. The next development was in May of last year, SAPS put up an affidavit which on our reading of it, conceded that the relief that would flow from the Equality Court orders necessitated a revision of the THRR, meant that it was no longer in dispute that the THRR needed to be amended. And so we stated in our heads of argument that the question of the need for the appeal against the failure to grant more extensive relief in paragraph 2 of the court's order had become largely, if not entirely, academic. And on that basis, we had not included in our draft order a provision dealing with it, because it was our submission then, and it remains our submission now, that that is no longer in dispute. It's no need for an order to be given in that regard. SAPS has argued on that basis that we've abandoned the appeal. And we submit that what has taken place does not amount to an abandonment of the appeal against the paragraph 2 of the order. It's no longer necessary to pursue it unless we've misconstrued the effect of what SAPS has placed before the court. And in any event, what waiver of a right requires a clear and unequivocal acknowledgement of that waiver, and that hasn't been the case. If we misconstrued the effect of SAPS's order and didn't include the appeal against paragraph 2 in our draft order, then that was certainly not be sufficient to satisfy the test for a waiver of a right.
The 15 minutes is up, Mr. Hawthorne. Still a bit of time or not?
I've covered the issues that I would like to deal with. Thank you, Justice.
Thank you very much, Mr. Hawthorne. Court Jen.
Justice Madlanga, if I might just take you up on your conditional leave to reply.
Yes.
And
How much time do you want, though? How much time?
It'll be no more than 5 minutes, if that. Justice Madlanga.
I forgot when I advised my colleagues about the time allocations, I forgot to say we had agreed that you would not reply except if you felt that there's something you just must respond to. Colleagues, there's that on the table, please. But how much time do you want, Ms. Christine?
No more than 5 minutes, Justice Madlanga. I'll be done within 5 minutes.
Thank you.
Thank you, Justice Madlanga. There are two things that I just would like to respond to in response to Ms. Williams's address. And the first is that the state respondents did not have an opportunity to object to the Women's Legal Centre's participation in these proceedings. And it was mentioned that whatever the procedure was that we were joined as a respondent is unknown, but be that as it may, at no stage did those state respondents object to the WLC's locus standi to participate in these proceedings in the manner that it did. And even assuming that Ms. Williams was correct, that they didn't have an opportunity to respond to the application and the affidavit, there is no reference, even in the respondents' written submissions, to illustrate that it took issue with the way in which the WLC was joined to these proceedings or the relief that it was seeking in these proceedings. And so on that basis, I submit that there's no merit in the complaints raised now in oral argument. The second issue—
Ms. Christian, what are you before us? I'm talking about your standing.
Justice Matoba, we have been joined as the fifth respondent before this. No, but
let you and I talk about it. Yes. Is this how respondents get joined? Or are you an amicus?
The role, as I've stated, I think it's stated in the affidavit as well as in the heads of argument, the role that the WLC is taking in this court is that of an amicus. The way that it came before this court was by fortuitously being joined as a fifth respondent, but the role that it plays is no different from that of an amicus.
So it doesn't matter what label we attach to you?
Indeed, Justice Matopa. It's a matter of form over substance.
Yeah, okay.
The second issue I wish to address briefly is there was reference made to page 651 of this court's bundle, where, to my embarrassment, there is a reference to gender-based violence in the revised THRR. And I hope this court will forgive me for missing that single reference in the conclusion, when in the body of the document, I didn't see an acknowledgement of the need to address gender-based violence. But even so, I will just clarify that that reference is used in conjunction with murder cases as a weight contributing factor. And all that that potentially could do is lead to a more hands-on deck approach. But as I've sought to illustrate, is that to address gender-based violence in the manner that is requires more than a quantitative response. It requires a qualitative response. And so even though I admit I missed that reference in the conclusion, that doesn't dispose of the issues raised in the Women's Legal Centre's affidavit and the submissions made. And those are all the issues I wanted to address. Thank you, Justice Madlanga.
Thank you, Ms. Christians. Cora Jane.
Today's proceedings have concluded. The court will continue to terminate